the connected.
With whom? All right. All right, we will see.
Actually, 4 minutes present. Board sub-item 2, sub-item 4. I had them intervention application minutes 2 IA. I have only 5 days. They are not being done. Sub-item 4.
All right, you give us.
In another matter, my lord, that is 2274 of 2024.
Please give us. Want urgent hearing.
Urgent hearing, it is, there was a direction to tag this matter along with WPC 19260 2024. 19260 2024 is already on the board, but my matter has not been.
All right, when the matter is listed, just let us know. Taken up, just let us know.
Pardon to mention that. Is that read appeal, my lord? Yes, the order of the learned single judge, my lord. It is relating to the allotment of a plot of land by the GA department, my lord. Even though the petitioner has appellant has paid the premium amount, my lord, despite that the land has been not been allotted to the appellant.
Give us. Please give your slip, Mr. Nam.
My lord, these are applications for restoration, my lord.
So how many cases you got dismissed for default?
1 writ appeal and 2 writ petitions
3.
for non-prosecution, my lord. Urgent, my lords,
Yes.
kindly listed.
To be mentioned, item number 1.
These matters, this will come for judgment on Monday.
For admission, item number 2.
Item number 2. Actually, it's a very sensitive matter that pertains to the appointment of the managing director, who is, my lord, otherwise styled as chief executive officer of a cooperative body. The present body is an Apex Cooperative Bank. But actually that carries on the major activity. It's a scheduled bank. The major share capital is held by the state government. So by virtue of your lordship's order, the registrar, who is the, my lord, your lordship knows the controlling authority of the register of cooperative societies, he is in charge Now the committee, my lord, they have been placed under suspension, my lord, under this section 32, which provides for the supersession. But though that is an appealable order, instead of waiting for the final outcome in the 32 proceeding, they came before this honorable court. There is some interim order, and the court has also been pleased, my lord, was pleased to pass an order that they can take any policy decision, which includes the appointment of the chief executive of the society or the bank. So therefore, my lord, what I'm praying, because the bank has to run, it is a scheduled bank around, my lord, entire NABARD funding, everything for the agricultural sector, all those, my lord, activities are being carried out by the financing through the state cooperative bank. Earlier, my lord, all chief executive was appointed from out of the Indian Administrative Service, my lord. The registrar is also a member of the All India Service, though not from administrative service. He is from Indian Ordnance Factory on deputation to the state government. But what I am praying, since his essential main prayer is for appointment of a regular managing director, so let the government will not appoint a senior member of the or any member of the Indian Administrative Service. That was being done because the committee cannot take the decision now. It is already being a supersession proceeding has been initiated. They have been placed under suspension. Out of 25 members, only 7 have come. Rest did not choose to challenge the 32 proceeding order. So the
the only question is that
Yes.
the body should run in accordance with law.
That's
all.
correct. That's correct.
So if
No, there is an order, Miller. Your Lordship may kindly turn to page 14. A division bench of this Honorable Court directed
therefore-
page 14, Miller, annexure 1,
yes, that we have seen.
para 10.
Yes,
That's a division bench order also, Miller.
yes.
The result will be that opposite party number 9 will hand over the charge forthwith to the Register of Cooperative Societies, and this arrangement will continue till further orders. That is also the order which was passed by the Honorable Single Judge also in some connected matters. That has also, Milord, I think that has not come. No, that is 32 proceeding. So therefore, Milord, the registrar is also a member of the All India Service. He was in charge, Milord, but the question is for the smooth and better management of the bank. So therefore, Milord, in the interim till the outcome of the 32 proceeding which is pending before the Honorable Single Judge, they have come for reference only, the other connected matters. This is the PIL.
32 proceeding is pending before the
Before,
registrar.
so therefore, Milord, I am praying that let a member government appoint any IAS officer, Milord. That was being done. It's because it's a scheduled bank. The government, your Lordship, may kindly look at section 33 capital A of the Cooperative Societies Act. The RBI is to be consulted, the 33(1), Milord. Capital A, sorry, 33 capital A. Order, Milord. In all fairness, they should have waited. So without Milord, 33 qualification, etc. of employees of societies. At page 63, if your Lordship is holding this legal miscellany book, your Lordship would find it at page 63. 33 capital A. It is again the registrar. Milord, may I read it? May I read it now?
Yes.
33. The registrar,
Which section?
section 33 capital A, Milord, of the Cooperative Societies Act.
Yes. Yes.
Lord, may I read?
Yes.
Let the registrar shall fix the number and designation of the employees to be employed by the cooperative societies, make rules regulating the qualification, remuneration, allowances, and other conditions of service of such employees. That the proviso is important. That says that the qualification of the chief executive officer of the state cooperative bank, let the petitioner, not this pertains to affairs of the Odisha State Cooperative Bank, and central cooperative banks shall be such as may be stipulated by the National Bank in consultation with the Reserve Bank of India. Because, Milord, the money of different national banks is also involved in this. It's the Apex Cooperative Bank of the state, which is a scheduled bank also. That is subject to Banking Regulation Act, Reserve Bank of India Act, and the consultation is also necessary. The government will now take that step to appoint. Ultimately, Section 123 also empowers the government to pass any order in the better, in the interest of a cooperative.
Who is how managing director has been appointed?
Managing director, actually, the section 28(3)(b),
Yes.
if your lordship would look at
Yes.
section 28(3)(b,
Yes.
that says that the chief executive of a cooperative society shall be appointed by the, 28, one second.
Yes. We are there.
Let's say, got it?
Yes. Yes.
Yes, 3B, subsection 1. Notwithstanding anything contained in this act, there shall be a chief executive for every society by whatever designation called, who shall be appointed on full-time basis by the committee. Such chief executive shall be deemed to be a member of the committee in the case of an apex society, and in case of such central societies as the state government may, by notification from time to specify. Similar this, they contain that the committee is to appoint. But the question is now the committee is facing a supersession process. And there is an order, judicial order of this Honorable Court, which has been passed in one of the connected matters which have come for reference, that they cannot take any policy decision. So because they are facing a supersession proceeding. Appointment of chief executive, who is the main functionary to run the day-to-day and all the etc., is they can take that decision now. So the bank has to run, because your lordship knows that the cooperative entire sector in the state is in shambles, and most of the cooperative societies have been shut down, many urban cooperative banks, etc.
Banks have to run in accordance with law.
No, that's correct. So, the interreg now.
They cannot run in accordance with law, then they will be shut.
Your lordship is correct, I bow down. But the practice was this. An IS officer was being appointed.
Practice we will not go by.
No,
practice.
that's correct.
Let him just start. What is the issue?
No, their matters have not come, It's the first matter. They have only come for reference. The other matters they don't have, this say. Other single judge matters, 5 matters they have come for reference only. Because there is already an order in writ petition number. Justice in writ petition number 22754 of 2024. That is in one of the writ petitions where they have questioned the propriety of the 32 proceeding. 32 proceeding itself is an appealable order under section 109 of the Cooperative Societies Act. So, I'm not going to the merits now for the time being. But the larger public interest has to be subserved. The bank has to run. So, in the interim, your lordship may make an interim arrangement so that...
No, we cannot make any arrangement. We cannot make any interim arrangement contrary to law.
No, now that the registrar is in charge, pursuant to your lordship's order, the registrar is in charge. Or the registrar may appoint, if he is the question is, registrar under the law is the authority to decide the 32 proceeding. They will be issued with a so-cause. They will be given opportunity of hearing. Finally, the registrar has to take a decision on the basis of the materials available on record or their defense in the so-cause. So that proceeding is pending. I think there is an interim order that it shall be kept in abeyance. So that's a separate thing we have to address the Honorable Single Judge. So now the question of appointment of the managing director, they call it chief executive under, but he's the styled as managing director. Your lordship directed, because of this controversy earlier that was there, now the situation is different also. It has gone a step further because the committee is no more there. It is under suspension, and by virtue of your lordship's order, your lordship may kindly turn to WPC number 22754 of 2024. Amita Patnaik versus State. That is by one of the suspended members of the committee. There are 25 members. Out of them, 7 have chosen to prefer writ petitions before your lordship. 18 are not there. There is no quorum. The committee cannot also meet otherwise. So therefore, the committee cannot possibly take any decision in view of the 32 order. So they have been suspended. 18 of them, my lord, are not before your lordship. 7 have come. So 7, my lord, the interim order is also confined to the particular petitioners. Even if they continue, there can't be a quorum. 1/3 is the quorum. Committee cannot meet. There is also a restraint order by your lordship that they can take any policy decision. My lord, page, your lordship would find order dated 12th September 2024, my lord. IA number, no, that's along with the main writ petition. IA number 12132 of 2024. Let in the connected matter, your lordship would find order number 1. The last paragraph, my lord, para 9. In view of the above, this court directs that letter number issued by the registrar so and so fixing hearing on the question of supersession of this shall be kept in abeyance till the next stage. It's a statutory proceeding, my lord. So it is further made clear, Committee of Management of OSCB may take decision for day-to-day affairs of the bank, but no policy decision, more particularly with regard to the appointment and posting of the managing director, shall be taken. So they can take the decision, the bank has to run, my lord. It is in the public interest and the interest of the, especially the farming sector.
But did you make any application for vacating this order?
Yes, we have filed an objection.
Application for vacating.
We have filed.
No, no,
Fine.
there is no requirement for, they say that they can take any, so the committee cannot take that decision. There is no restraint order for the state to take a decision in the interregnum. So therefore, my lord, till the final outcome of 32, this way or that way, that may be decided. We do not know what would be the outcome, but still the court has said that.
No, but
So this appointment is a policy decision, managing director. Managing director is the key person so far the affairs at the hem of affairs is concerned. This committee gives it, so therefore, my lord, in the better interest, since this is a PIL, he has come, my lord. So therefore, let an officer of the government be appointed in the rank of Indian Administrative Service.
no, why?
So nobody, then the registrar is there, my lord. We don't have, my lord, registrar is already there by virtue of a judicial order. Registrar is also a member of the All India Service.
Yes, who is for the?
Petitioner is not there. I am told that he is admitted in hospital.
Who?
The petitioner's told, I don't know. I may be wrong also, but.
Who is the
they
petitioner's
told
counsel?
me that the petitioner's counsel.
Yeah.
He is not well. So what told. Like connected matters. We are all appearing in connected matters. So far as the PIL is concerned, Mr. Sakridhar Tripathi is the London Council appearing there.
Yes, those matters have nothing to do with it. So that they are
PIL
single case matters.
In the PIL matter, I was appearing for the bank. Your Lordship wanted to know that why the managing director is not being appointed. Because of the interim order passed in the other connected cases, therefore.
No, I think you are appearing for one of the suspended committee members.
No. I am appearing for the bank.
Bank.
Same. Our difficulty is, Mr. Acharya already addressed your Lordship so far the registrar's power is concerned. Our managing director can be appointed only by the managing committee. That's a different question. But the question is now, your Lordship, the earlier writ application which was filed where a person was appointed by the government was quashed. And this Honorable Court directed the registrar to take over the charge.
Right.
The registrar is in charge of that committee of management. In the meantime, committee of management has been superseded and some order has been passed on suspension for some of the members. They have
No, not superseded. Pending supersession proceeding, they have been suspended under subsection 7 of 32(7). No, there is no supersession order so far. It's a suspension order, which they came before your lordship.
order of
Suspension order, my lord, that has also been stayed. I'll, my lord, that I'm not going into the merit for
So
it.
why 32 proceeding has been stayed?
My lord, there are lots of malfeasance and, my lord, irregularities. The committee was not functioning. They were not. And one of the allegations is that they did not take steps to appoint the managing director. Lord, one of the charges in the 32(1) proceeding is, my lord, for not taking steps for appointment of the managing director, notwithstanding, my lord, so many orders of this Honorable Court. On 3 rounds of litigation, this court directs that the managing director should be appointed by the committee. They failed to do that. So therefore, my lord, this order has been passed finally. So, and that is one of the charges in the 32 notice, focus notice. They didn't reply to that, came before this court. That's a separate, my lord. I have been repeatedly submitting that. That's the subject before the honorable single judge. So now the question is with the government appoint now. Because the bank has to run, that is the problem. Register is there. If your lordship, it
Mr.
is
Rath,
there.
as you suggested
If I can.
in your, you were arguing that matter.
Yes, Lord, if I can make a submission on the question of appointment of CEO. If your lordship sees there are two judgments passed by this honorable court, one by the honorable division bench, other by the honorable single judge, directing the committee of management to take steps for appointment in terms of the rules, act governing the field. Now, the committee of management, after the judgment, committee of management, prior to the supersession and suspension issue arose, they have passed 4 consecutive resolutions for taking steps for appointment of the CEO. If your lordship sees section 28(3)(b)(1), right? 28(3)(b)(1), appointment of CEO can be made by the committee with approval of the registrar. And if your lordship sees section 33(1), 33 capital A, qualifications and data things are to be approved by the registrar, and National Bank is also empowered to prescribe the qualification. Now, after having passed these resolutions, we have referred the matter to the registrar. Now, registrar is to take a call. Registrar, who is the MD himself here, registrar, who is in charge of MD himself here, is a member of the committee. He has passed order to place the matter before a screening committee, which is not there in the Cooperative Act and rules. Now, at the behest of registrar, the whole issue is deferred, and the committee was not able to appoint the CEO because of the impediment created by the registrar, who is in charge of the MD. Now, control of the whole bank in a process your lordship will appreciate. I can show those documents there on record in this 19-260-24. These resolutions are on record. The registrar's order is on record. The government has passed order restricting the committee not to appoint and place it before a screening committee, which has no sanction in the eye of law.
So no, that's not.
Committee has.
All right, we will take up the matter again. In fact,
That's not the
go
case,
through
my lord. Your lordship can
we shall
kindly
go
look at
through the
this.
statutory provisions and we will see what can be done.
As your lordship.
So, my lord, actually, my lord, that is, I do not want to go to the merits of this single bench. My lord, one of the charges, the foremost charge is, my lord, for not taking steps for appointment of the managing director for the last 1.5 years. And they are not following the modality which has been prescribed by the NABARD and the Reserve Bank of India. The government can't appoint any Tom, Dick and Harry. Has to be conform to the norms of the appointment and the qualification, etc.
We will see, and because of 2 orders passed by this court and statutory provisions and present circumstances, we need to examine the statutory provisions.
Very correct.
Right. Now that, my lord, the registrar is in charge. There is no issue. The registrar is in charge pursuant to your lordship's order. Is in charge.
We'll see.
There is
On.
Like in this matter, sub-item 4, when I was mentioning in the morning, those 2 IAs may be doubtful. I have intervened in this matter, sub-item 4.
And this,
Who are you?
Well, I'm an intervener. I'm an ex-managing director of the bank.
All right.
my matter has not been tagged, my lordship.
Definitely.
Another connected matter has also not been tagged.
Yeah. How many matters are there?
Malaj, as per my instructions, there are 2 more matters which have not been tagged. They are 2274 and 22437 of 20. Both matters. Yes.
224.
I will give it.
So how many legal issues are involved?
This is the only legal issue.
What?
that whether the managing director can be appointed by the managing committee, that is one. The second is the rule has not been amended in terms of the provisions of
So there are two legal questions according to you. Frame that, give that, we'll answer that.
You also hear this matter.
Lakshmi will hear it and decide.
Also the qualification requirements of the managing director. That will also be there.
That will enlarge this.
That will also be there, no, that fundamental to the
But it's
to the decision.
Definitely, we will be appointed.
But please just frame the questions,
Yes, sir.
legal questions
Formulate-
with reference to the statutory provisions.
Yes, right.
And then let us answer those questions.
The law decided. Very much.
Correct.
Great.
well, it's interim orders to continue.
Interim orders have got to be-
On interim order.
No, 1 week.
Huh?
Is there any interim order?
No, Lord, we just interim order.
These are not taken.
But there is no interim order in the PI.
All
In
right.
the PR,
The other connected matters that are interim.
How can that order be
It will
passed?
come after 1 week. Let us see
So
what.
that's before the
No,
honorable
no,
single year.
Item 15. That if you also remember that is with respect to that mining matter, that was specifically fixed to 2 PM today. But somehow, since the
Which matter, mining?
Those matters will not be.
All right.
So
All right.
2 PM, there is no bench. I was,
All
there
right.
is single bench.
Let it last date, Lordship order to be listed, to be taken up at 2 PM. So that has come in item 15, today's list.
Oh, today because there is no division bench.
Yes.
So what can be done?
Your lordship
What
may
should be
fix
done?
Another date your lordship may fix.
No,
Possibly,
if the lawyers have come,
No,
the
nobody-
senior counsel have
no
come,
lawyers.
then in that case,
so lawyers.
no, lawyers are from outside.
I think
Have
my
come
lord-
means you are already here. So if the senior lawyers have come from outside and it is going to put to them any inconvenience,
No, I
then we
think
can take up the
nobody
matter
has
at
come.
2 PM. Otherwise, we will fix
May I propose the first
My lord,
week
may
of,
I
November?
make,
first week of November. First
My
week
lord,
of
may I
November on.
My lord senior
Yes,
is
yes,
allowed.
please, Mr.
Mr. Subramaniam is there.
Subramaniam.
yes, my lord, I wanted to just recollect, my lord, that on the last occasion, the learned advocate general was very gracious in making a suggestion of some kind of an interim solution. And I had also made a submission. A suggestion could be
We do
shared
remember.
with us, and we also would make some proposals. But Lord, we have not been able to go through with that exercise. So if we could go through with that and have a productive hearing when your lordship takes up the matter on the next occasion, I think it would be most appropriate.
Monday,
Tuesday.
Tuesday. Tuesday again, Wednesday, I generally sit single.
Then my lord.
So if-
7th of
Thursday,
November?
We can split Thursday and Friday.
Let it be on Monday, Mr. Let it be on
11th.
Monday. Then
11th.
only you'll get two this thing, full hearings
Then Monday, my lord.
at 2.
the
Monday and Tuesday, we can.
11th Monday. 11th, huh?
Fourth.
But I may remain absent on 4th and 5th. 11th.
11th, Mr.
I was only requesting,
Very
not Monday, if you don't. Tuesday, Wednesday, Monday is a little difficult. Monday and Friday are a little difficult.
Monday and Friday, then
little
Tuesday,
difficult.
Wednesday, the court has
Matter. I'll appear on VC, not sure.
Monday and
Yes.
Monday, Tuesday, Monday.
It would be 2 PM. The Supreme Court matter gets over by lunchtime. So it will be. No. So Monday at 2 PM, that's.
He wants to address the court physically. All right.
11th at 2 PM.
Cases were directed to be taken up at 2 PM today. Stop. However, the bench is not available at 2 PM today. Stop. In such view of the matter, as consented by the senior counsel, plus senior counsel appearing on behalf of the parties, list these matters on 11th to be taken up at 2 PM. Grateful.
Grateful.
I will
would it be possible to take up that item number 26, that matter where your lordship directed chief secretary to take a call?
We will take up the matter. We'll take up the matter today. Who is for the other side?
State.
Only state.
National highway.
We will take up the matter at 12:30 or what?
Matters under the heading orders, item number 11.
11, my lord, from the last date on 18/9, your lordship directed to take steps for substitution of OP4, my lord. They have filed the IF for substitution. Lordship, that may be allowed, and notice may go to OP4 and as well as OP3 also. And for OP5, my learned friend is already appearing. At flag A, my lord.
Which item is this?
Item 11. For substitution, all right.
What happened?
Substitution as well as condemnation.
No condonation of delay of what?
Filing this, that is not required.
Condonation of delay in substitution.
Actually, my lord, sir,
No, that was filed as
subsequent,
filing of the CMA claim, so that is not necessary. That
because already
(7/3 of 2024). Issue notice to the proposed legal errors by registered. This is an application for substitution of deceased opposite party number 4, who is stated to have expired during pendency of the CMAPL. CMPL. Issue notice to the proposed legal errors by registered post with AD. Full stop. Notice should list on for the list on 20/11/2024. Returnable date shall be fixed. Returnable date shall be fixed within 4 weeks. Requisite shall be filed by Wednesday. Filed by 26 Saturday. Requisite shall be filed by 26/10/2024.
lords, also to OP3, my lords, notice may go because no one has appeared. OP3, my lords.
Nobody has appeared means earlier notice had.
Earlier in another CMEPL they appeared, but
No. In this has notice been issued to the.
OP3 also notice has to go. No one has appeared.
Just one moment. Condemnation. Notice in the matter of condemnation delay had been issued.
Let notice go, my lord, for OP3 also.
Okay. To the proposed legal errors as well as opposite party number 3.
God bless me.
All right, 27.
Item 12.
Item 12, my lord. I am for the respondent 1. I may be allowed a copy of the data of it. So I will find my reply.
So what is the delay?
That in 2 cases, my lord, there is delay. In first case, there is delay of 289 days. And in second case, 300 days.
Let him file up.
Well,
You are appearing in the first case.
First case.
All right. Yeah.
Otherwise, we are ready to impose cost. We are ready to allow the temptation petition with cost. Get good amount.
I'll find my order.
He wants amount from here also. You are Mr. Mishra.
Mr.
Acha. On list the case on Third, list the case on 13/11/2024 to enable Mr. S.K. Mishra, learned counsel appearing on behalf of the respondent to file an objection. IA 519 of 2020 to file an objection to the application for condonation of delay. Full stop. Same. You want to file an objection? Okay. Same order in WA 465 of 2024. Only thing, counsel's name will be Mr. Subhadatta, and list with this list with that and this other list.
Copy of the rate of. Yes, yes, I will start. With that. Limit is. At note 13.
My lord, we have filed the application for preponing the date of hearing for a very specific reason. If your lordships can take up the IA.
My lord, yesterday the copy is served on me. My instruction is this is regarding that NOC, where the application were the deficiencies were rectified after the time scheduled. But my further instruction is there are a lot of litigations have come and a lot of cases are pending and for inspection. So they have given a WhatsApp message that I don't want to place it. In view of the multiple grievances, we will take steps to online inspection of all the institutions which has not been inspected with leave of the Honorable Court immediately after the impending cyclone. If cyclone is not there also, we will do it. And accepting for those who do not have valid fire safety certificates. All the institutions we want to inspect whether it is high risk. That's why they have the instruction I have got. So in this case also we can get for inspection. If inspection is there, NOCs can be given, the things will go on. No problem.
But there is a small hitch in it. The reason being, as per the INC guidelines, everything has to be concluded by 31st of October and the admission in the classes has to start from 1st of November. And prior to after getting the NOC, there are certain
no, but this cyclone is an
no, I don't know, my lord. I am not on that.
And it's a very good excuse also.
No, my lord, we have also trying to write to the INC for extension of time for this thing.
Because otherwise what happens, my lord, even if we get everything, because the INC guidelines have not permitted beyond 31st of October, that exercise will become in.
We will take care of
that.
Yes, that.
Later, all these matters come on 28th. This matter 29th because tomorrow day after there may not be court. The cyclone.
There will be court.
No, but we. So I have told them. So I have instructed them to go for inspection. So I will file the affidavit and 28th all the cases will be disposed of.
And this is my record.
Yes.
Yes, statement only.
Yes.
So counsel appearing on behalf of the DMET has submitted
this. I don't like this cannot.
He has received instruction from the DMET to the following effect.
There's the counseling process and then the fees, payment, everything, there's a guide.
That will be extended. No
so that also has to be taken care by my senior's client. Because we can't do that with the INC guidelines already being there and your lordships.
I will take care of. As requested by him, list this matter on. Requested by him in view of the aforesaid instruction, list this matter on. There are two matters or how many? One.
Today there are two matters, but there are a lot of matters. If your lordships can fix it at 2 p.m., 28th at 2 p.m. So that
yes, ma'am.
Retaining its position.
Yes,
or your lordships pick it up under orders, heading orders also, that will be subject to your lordship's convenience. Same maintain. Orders can, yes.
Along with.
14 also, same order will cover, though slightly different issues.
Only
there, but
14. The date has been different. That order has been made on 7/11. That should be 7/10. That order has to be,
Disposal of matter.
yes, my lord.
Yes.
Yes. 710, it should be instead of 710, 11.
Yes.
Orders matter over. Supplementary list item number 1.
There was a direction for taking instructions from the BMC. But I was informed by the commissioner, they're all engaged in preparation of their measures to be taken this. Once I go. Can it be the first week? Are you both of people?
Senior counsel appearing.
Interim order may be continued.
Senior counsel appearing on behalf of the Bhubaneswar Municipal Corporation states that because of the cyclone alert, the officials of the corporation are otherwise busy and he could not get instructions. So staff has requested by him this matter on Monday, Tuesday.
Next week or the
Hello?
Next week.
5th November.
With
5th November.
fifth.
Item number 2.
Wait, please, my lords.
on this week.
Yes.
My lords, in compliance of the last order, we moved the application. Unfortunately, the cause list doesn't reflect that. My lords, we have filed it. We have served the other side as well. And that's on the court's file. If your lordship will have the last order. There are two things that were directed, my lords.
Yes.
Yes.
Where is the
First
order?
Yes, your lordships have the last order. 26th of September, my lords.
Okay, 5589.
So you have filed IA.
Yes. Yes, my lords, we have.
5589.
Yes, my lords.
1419.
14190. 14190, my lords.
I'll just wait. Here.
Where is the Supreme Court's order?
The Supreme Court's order was in that application we had moved, my lords. If your lordship will have page 26.
We got it.
Yes, page 26, my lords.
Who is appearing for the IDCO?
I am appearing.
Have you received the copies of the amendment application?
I have received that. Petition, what my learned friend is referring, that is not 14190.
No, 1419 is for deletion.
Yes, but amendment is 5589 of 24.
Yes.
But what I find, Your Lordship has gone through the order of the Honorable Supreme Court. It has been confined only to modify the order if an alternative plan can be considered to be allotted. But he has expanded the scope, stating that the content proceeding
So you file an objection.
will file an objection.
You have filed.
No, we have not filed. Your Lordship may grant 2 weeks' time, we will file the objection.
When did you receive the copy? I think long back.
No, 3924.
Okay.
No, because in between holidays are there.
IA number 14190 of 2024. This application has been filed for deletion of opposite parties number 6 and 7.
No, that may be allowed at his
The
discretion.
array of the opposite parties. So, this application is allowed. Let the opposite parties number 6 and 7 be deleted from the cause list. Sorry, cause title. Also. The petitioner's list. Stop. Next, IA number 5859. 5589 of 2024. This application has been filed seeking amendment in the writ application in the light of certain observations made by the Supreme Court in the order dated 15/9/2023, passed in SLP bracketed civil diary number 34530 of 2000.
Yes, my lords.
So, learned senior counsel appearing on behalf of the opposite party, IDCO.
3. OP number 3.
IDCO bracket, opposite party number 3, bracketed IDCO, seeks adjournment to file a reply to file an objection to the said amendment application. Stop as requested. This matter on how much time? 2 weeks to file an objection. So as to enable IDCO to file an objection to the amendment application. Yes.
Item number 3.
May my lords only request, if your lordship will permit, my lords, we'll file a rejoinder to that and then your lordship.
Whatever
Joined.
amendment, objection, rejoinder, and the main matter. Let us see.
Very well, my lords. I'll leave it to them.
Item 3.
Well, I beg to appear for the petitioner as an item 3.
Yes.
Yes.
Yes, Mr.
Yes. Yes. Well, the Lordship sees, well, our challenge to the rejection of our bid is the subject matter of the present petition. And if your Lordship straightaway comes to the rejection letter on page 157.
Yes.
And if your Lordship has, in the table on page 157.
Yes.
Serial number 2, we are NCC Limited.
Yes.
And in the remarks column, on the second column from the right, the reason is set out.
Yes, but we cannot, that is not legible.
My colleague, I think, is carrying a
copy.
They have highlighted so that.
Because You have attempted to highlight that, and in that process.
I'm so sorry. I'm so sorry. I think my colleague has a.
Page? Page. Page is 157. Yes, please.
Yes. Must please have the column under the head of remarks, which is second from the
Conflict of interest.
Yes. The bid has been disqualified having conflict of interest as per clause 2.2.1b of RFP and rejected under clause so and so of the RFP. EMD deposited during the bid submission forfeited as damages so and so. So one of the reason for disqualification is a conflict of interest. Now, let's please kindly have the provisions that they refer to, which is 2.2.1 of the RFP on page 57.
Yeah, we remember this case was earlier heard.
Yes, the Lordship had passed an interim order.
Yes.
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 Last time my matter came up, Millets. Now that matter came up. There's a difference.
Yes.
Now, please kindly have on page 59. And if Lordship has the title is eligible bidders, which is 2.2.1. And if Lordship has subpara B. And in subpara P, it is sufficient to see the last sentence before the subpara 1, which says the bidder
It's
shall.
impossible, Mr. Sethi, it is impossible for us to read because
sorry.
All the relevant lines have been highlighted and therefore they are not legible.
I'm so sorry, I had requested my colleague to give a better copy.
No, page 59. This one. Yes.
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 Does the Lordship have paragraph 2.2.1?
2.2.2 you said. 2.2.1.
Yes.
Yes.
Which is on page 59.
Page
57.
59.
I'm so sorry, I think page 57.
57, yes.
Your Lordship has the title says eligible bidders.
Yes.
And under that, please straight away come to subpara B. If I can read this, a bidder shall not have a conflict of interest that affects the bidding process. Any bidder found to have a conflict of interest shall be disqualified. In the event of disqualification, the authority shall be entitled to forfeit an appropriate security or performance security, as the case may be, as mutually agreed genuine pre-estimate loss and damage likely to suffer and incurred by the authority, and not by way of penalty for inter alia the time, cost, or effort of the authority without prejudice to the other right or remedy that may be available to the authority under the bidding documents and on contract agreement or otherwise. The next is important. The last sentence is important. A bidder shall be deemed to have a conflict of interest affecting the bidding process if then it sets out certain grounds on which it would be deemed to be a conflict of interest. And what is relevant for us is the next page.
58.
58.
Right.
Roman 5.
Yes.
Such bidder, its member, or associate thereof has a relationship arising due to ownership, holding / cross-holding with another bidder, its member or an associate thereof, directly or through common third parties that puts either or both of them in a position to have access to each other's information about or to influence the bid of either of each other. Now, this clause that they seek to invoke to non-suit me and to disqualify my bid.
Yes.
And Malas, in the rejection letter, of course, it is not made clear. But if we look at their counter affidavit,
yes,
their allegation is, Malas, that the petitioner before Lordship, who's one bidder, and BGR, who for the present contract, have in the past have joint ventures which then resulted in consortium SPVs and are executing those other third-party contracts. And by reason of their being members of that SPV, they have contacted conflict of interest.
yes,
So therefore, please note, just to put the fact matter at place, Malas, in two earlier contracts, the petitioner and BGR came together to form a special purpose vehicle to execute mining contracts. And in those SPVs, NCC and BGR are shareholders. And of course, their nominees are on the board of directors.
yes.
Now, Malas, please note, Malas, the petitioner and BGR are independent companies. They came together.
The SPV was created by both of them and NCC.
By both of them. And Malas, they are shareholders in that SPV. In one case, Malas, 51 and 49.
Yes.
So the question is, Malas, being parties to an SPVs in some other contract will amount to conflict of interest in the present contract.
Yes.
So in this light, please kindly have this provision again, which is subpara 5.
Yes.
Such bidder, its member. So the member part will not apply because these are individual bids. So such bidder, which in this case is NCC, or any associate, I have no associate in this bid, has a relationship due to ownership, holding or cross-holding with another bidder, its member or an associate directly or through common third parties that puts either or both them in a position to have access to each other's information about or to influence the bid.
Yes, Mr.
Now, Malas, please note, Malas, that provision as it reads, Malas, a common shareholding in either the petitioner bidder or the other bidder. So either I own the other bidder, that's by the reference to ownership, or I hold shares in the other bidder.
Yes.
Or there is cross-holding, which Lordship has, Malas, generally happens if the bidder has a holding company, and in the holding company there are cross-holdings. The sum and substance of the matter is, Malas, whether there is any commonality of shareholding or ownership as between the petitioner bidder and some other bidder.
According to you, there is no commonality.
I'm so grateful. It's nobody's case that whether I hold shares in BGR, the other bidder, or BGR holds shares in the petitioner NCC.
Yes.
So neither of us must hold any shares in the other company. neither of us, Malas, have directors in common. And we compete against each other regularly, Malas, in various contracts. But Malas, for the purposes of subpara 5, which in my most humble submission must be strictly construed because that's a disqualification clause.
Yes.
We must read as to what was prohibited.
Yes.
Now, Malas, please kindly, if it also kindly has the counter affidavit filed earlier before the dismissal of this petition, because they filed an additional counter later.
Yes.
Of Malas OP1.
Page. Just a minute. Yes.
Does the Lordship have that, Malas? Malas, please kindly have off that counter internal page 8.
Page 960. Yes.
Well, please kindly have internal page 8. And if Lordship has on top, 3 bidders are set out. The petitioner NCC, BGR Mining, and BGR Malas, the other bidder who said to be in conflict of interest with me. And now please kindly have the last on that page, Malas. Reading the tender committee in his meeting held on 6th of March examined the techno-commercial bids of the bidders for scrutinizing downloaded documents of 3 bidders as per so-and-so. Please turn the page, Malas. And then in the table, Malas, they refer to the petitioner's experience. And one of the experience, Malas, claimed by us is at serial number 3. And in the middle column, it sets out, Malas, that is NCC BGR Consortium. And it refers in the next column, Malas, the name of the SPV called Panchwara Coal Mining Private Limited, an SPV company. Then please have paragraph 9, Malas, humbly submitted that in the connection to the work experience submitted by the petitioner, as shown in the table above, serial number 3, petitioners uploaded the following documents. Work experience in the above table is associate has been defined in clause so-and-so. It is submitted that as per clause 2.2.4 in computing technical and financial capacity of a bidder, the technical capacity and financial capacity of the associates would also be eligible, and a bidder is permitted to submit and rely upon the experience of only one associate for the purpose of qualification. Then, Malas, please kindly have the clause which is quoted is 2.2.4 as to define associates. In computing technical capacity and financial capacity or any member thereof, where the bidder is a consortium, the technical capacity and financial capacity of associates would also be eligible thereunder. Clarify that a bidder or any member thereof, where the bidder is a consortium, permitted to submit and rely upon experience of one associate for purpose of qualification. The next important, for the purpose of this RFP, the expression associate means in relation to the bidder oblique member, a person who is, please mark, Malas, controlled by such bidder oblique member. As such, as used in this definition, the expression control means with respect to a person, which is a company or a corporation, the right to appoint or cause appointment of more than 50% of the members of the board of directors of such person, ownership directly or indirectly of more than 50% of the voting shares of such person, and with respect to a person which is not a company or a corporation, the power directs also.
Yes.
Now, Malas, it goes on. I will skip some part thereafter. And they referred to Tallapalli Coal Mining Company, which is the second SPV, on internal page 18, paragraph.
Yes. Which paragraph?
This paragraph 16 on page 18.
Yes.
Observe that the names of both above directors of Tallapalli are associated with NCC as well as BGR, which is as under. They refer to Mr. Raju, associate with NCC, who's the authorized signatory for the tender in question.
Not in the board of NCC.
And the second director is Mr. Bathina, who's from BGR and is a member of the board of BGR. And then please note paragraph 17. In view of the submission made above and the documents annexed, it was evident that both petition BGR are associated with a special purpose vehicle company incorporated under the Companies Act, namely Pachwara Coal Mining, having share of NCC 51% and of BGR 49%, which is currently active and already executed mine developer project for Panchwara Coal Mine with a stipulated period of 29 years. The registered address of Panchwara is so-and-so. Mr. Raju, director for this authorized signatory for this tender, invited under so-and-so has submitted the online bid with a price bid of Banthia director as well, and so-and-so, so-and-so. So therefore, please note, this so-called conclusion is on the basis, that both the petitioner and BGR are shareholders in an SPV. And their understanding is by virtue of this shareholding in an SPV, they have a conflict of interest in terms of point subpara 5. And then please kindly have page 23, paragraph 22.
Yes.
In reply to paras 1 subpara B of the petition humbly submitted, that there is enough material as per annexure so-and-so to show there is a conflict of interest of petition BGR. The directors of both Panchwara and Tallapalli are appointed by its shareholder NCC and BGR. It is apparent that Tallapalli and Panchwara are virtually controlled by NCC and BGR. Therefore, this is the conclusion. Therefore, the associate of petitioner, which is Panchwara, has a relationship with another bidder, BGR. Therefore, petitioner has a relationship due to ownership, holding, cross-holding with another bidder, BGR, through common third parties, which is Panchwara and Tallapalli. So, their conclusion is this.
Yes.
That the two companies, SPVs, are my associate and the associate of BGR. And by reason of this relationship, there is a relationship of ownership, holding, and cross-holding.
Yes.
Now, in my most humble submission, this balance to the provision in question.
Yes.
If you also kindly comes back to this the RFP provision.
Yes, yes.
Your also has my subpara 5 again. Such bidder, which is me, or its member, that doesn't apply because there is no membership in my bid, or any associate thereof has a relationship, holding or cross-holding with another bidder. So I pause here, Manas. I don't have any relationship.
Just a minute, Mr. Let us come to the impugned decision.
Yes. Well, that your lordship find is on page 157.
Yes. Election 4. Election 4.
No, but it doesn't refer to 5 only. It refers to 2.2.1b.
Yes. It only refers to that. Lordship is absolutely right, Manas.
It doesn't refer to only Roman 5. It refers to whole this thing.
No, Manas, why am I talking about 5? Because why I am referring to Roman 5 because their counter affidavit refers only to Roman 5. Otherwise, I can read the other provisions also, but may read those. If Lordship comes back to page one page earlier.
Yes.
Where the disqualifications start. If Lordship has the last sentence of 2.1b, the bidder shall be deemed to have conflict of interest affecting the bidder if 1. The bidder, its member or associate, or any constituent thereof, and any other bidder, its member or associate thereof, have common controlling shareholders or other ownership interests, provided that disqualification shall not apply in cases where the director indirect shareholding of a bidder is member or associate thereof, or any shareholder thereof having a shareholding of more than 5% of the paid up or subscribed share capital of such bidder, member or associate case may be, in the other bidder, is member or associate is less than 5% of subscribed and paid up equity share capital, provide further that this qualification shall not apply to any ownership by a bank, insurance company, pension fund, or a public financial institution in section 272 of the Companies Act. For the purpose of this clause 2.2.1b, indirect sharing held through one or more intermediate persons shall be computed as follows. A, where any intermediary is controlled by a person through management control or otherwise, the entire shareholding held by such controlled intermediary in such other person shall be taken into account for computing shareholding of such controlling interest in the subject person. And B, subject always, of course, A above, where a person has not exercised control of an intermediary which has shareholding in the subject person, the computation of indirect shareholding of such person in the subject person shall be undertaken on a proportional basis, provided, however, that no such shareholding shall be reckoned under this subclause if the shareholding of such person in the intermediary is less than 26%. And subpara 2, a constituent of such bidder is also constituent of another bidder. 3, such bidder or its member or associate thereof received or has received any direct or indirect subsidy, grant, concession of loan, or subordinate debt from any other bidder, its member or associate thereof, or has provided any other subsidy, grant, concession, loan, or subordinate, or to any other bidder, member, or associate. 4, such bidder has the same legal representative for purpose of this RFP as any other bidder. And of course, 6, such bidder is member or associate thereof has participated as a consultant to the authority in the preparation of such documents designed for disqualification. So, after reading all of this, the only one relevant for us, in my most humble
You were referring to Roman 5 only.
Yes.
Because according to you, in the counter affidavit, they have referred to Roman 5 for the purpose of your disqualification.
That's one. Secondly, in the counter affidavit, there is no reference to any other so-called
except Roman 5.
As also any other requirements or conditions of other clauses.
All right.
Which would kick in. And in the conclusion part, they use the same terminology as Roman 5.
Yes. Yes, Mr.
Yes. So therefore, what is critical for Roman 5, just to re-emphasize, is the ownership of the bidder or the other conflict interest bidder in shareholding in the respective companies. So this would arise only
if there is common shareholding or cross-holding.
Or that the holding companies of the respective companies have a cross-holding. So either at this level, there is ownership of shares, or at the next higher level, there is ownership of shares. Merely because they have done business prior in SPV or another contract would not be a disqualification provision. But this is also significant because the same RFP permits claiming of work experience of a prior work done as a consortium member or a simple member. And that becomes clear from paragraph 2.2.2 on page 59.
Yes.
And if your lordship has, the heading is technical capacity, but please have the unnumbered fourth. If the bidder was a consortium member in the claimed work experience,
no, but that is different, Mr. Sethi. Here you are competing with each other.
Yes, absolutely. I fully agree with the lordship. I fully agree. All I am saying is, they entitle you to take the experience of a prior work which was done as a consortium.
That is whether you can compete with each other or not is the question.
Quite right. I'm full agreement. Now, submission before lordship is that assuming this was in the rejection letter, there is no such detailed analysis of what was wrong with us. And surely it was open to them to seek a clarification which the RFP entitled, which is clause 3.7.1 on page 73. But they chose not to avail this provision to seek any clarification from us with respect to the SPVs.
But that is a discretion.
That's right. But I'm only saying, they had the discretion to seek any clarification. They chose, of course, not to do that for me to clarify any matter qua the SPVs. Now, please also consider something significant that we have been awarded a number of contracts, that is NCC, in similar circumstances, because these SPVs date back to 2016. And this conduct was not found to be a conflict of interest.
Yes.
Now, please also consider that Coal India itself has issued in subsequent tenders an express provision clarifying this matter.
Page 13.
If your lordship has our rejoinder to OP1.
Starts at page 13.
Yes.
That's for the annexure 16 on page 13 of the rejoinder.
Annexure?
Annexure 16, 16 on page 13.
Yes.
And if Lordship has, this is issued on the 27th of October 23 by Central Coalfields, falling under the same ministry. This is from development and operationalization of Sangha Mitra OCP. And please have the relevant provision on page 34.
Page 34.
34
of the rejoinder.
Of the rejoinder.
Which annexure is that?
Well, this is the same annexure which continues up till page 34 and thereafter.
Next 11 or
16.
This is your rejoinder to the counter affidavit filed by opposite party number 1.
That's right. I'm so grateful.
There is one annexure.
Yes, this is, I'm sorry, but this is the rejoinder to the additional counter.
Additional count.
I'm so sorry.
This is filed on 25/9/24, madam.
Yes.
25th September, after the last date of hearings.
Other provision then.
459.
Page 16.
459. Page 1199. Digital.
1199.
Yes.
Right.
No, that is again before they have been scanned the same thing twice. No. The scan ही नहीं होता. The same counter, it has been scanned again. So I'm sorry, that is already there earlier, again they have filed.
But there is no pleading in the name of rejoinder to the supplementary counter affidavit.
Well, it is
affidavit by petitioner to additional counter.
Well, it's called.
It's been filed, my lord, on 25th September is what we have the copy that's received. 25th September 2024.
Well, the title is
Lord, after the last date of hearing, my lord, your lordship last heard on 23rd September. 25th September, this affidavit is dated. It refers to a document of October 2023, a new tender.
Seems it has not been filed, Mr. Sethi.
Oh, I'm sorry.
Not there on record. Is it there on record?
I'm sorry. Because I was unfortunately told that it's on.
It is not there.
Could you please repeat the date?
Sorry, my lord.
Pilot?
To 25th September 2024, my lord. We have received a copy on that date.
It is rated also 25th.
And dated,
Your is.
no, of course, my lord. I'm not disputing that. The certificate date of the learned advocate is also 25th September.
I'm sorry, Malad, I was under the impression that it's on record.
Yeah, sorry. Not tagging the right.
We have the court PDF record also, my lord. We don't find it on the PDF record.
I soft copy. My hard copy.
Mr. Rao, are you sure that's your file?
I have just given copies.
Yes.
Just come back within 5 minutes. 3 minutes. Page?
129 is part of the reproduction. How can it be? They have not page mark. Is there?
No. Give your copy.
I've given.
Yes. Yes. Malas, please kindly have an
Let's have another copy.
Yes, please.
Yes. Malas, please see, this is Malas a RFP and NIT by Central Coalfields, which is coming from the same ministry as the present one, of 27th of October 23. And the description of work is development of possession of a Sangha Mitra OCP and for 25 years. Please have Malas, the relevant part for us, Malas, is on page 34.
Yes.
And if Rochup has Malas, the title is 2.2.1 eligible bidders. And in the middle of the page, Malas, just above paragraph C.
Yes.
There is a note which says, if the members oblique partners of any I'm so sorry.
Yes.
If the members oblique partners of any consortium involved in the participation and oblique execution of some other project participates in the present tender as an individual or a member or partner in different consortium, the same shall not be construed as conflict of interest subject to other stipulations.
So this was removed.
No, this was.
This is subsequent.
This is subsequent to the present NIT.
This was subsequent to present NIT.
Yes.
This was not there in the NIT in question.
That's right. That's right. But sir, I only want to show this to bear out the understanding of the authority as to what is and what is not a conflict of interest. Yes. Then Malas, we've also given Malas the MCA data of both the petitioner and BGR and the SPV. The first one of the petitioner Malas is on page 60. And extra 19. And extra 19, page 60 of this rejoinder.
Yes, 60. Yes.
60 Malas. 60. This is Malas from the MCA side, Malas, of the petitioner. It gives amongst others the list of directors on page 61. And then Malas, the MCA status qua BGR, the other bidder, on page 62. And their directors Malas on page 63. There is no commonality of directors. And Malas also of the SPB Panchwara, which is on page 4, and their directors on page 65. So there is no commonality, Malas, of the directors. Also the government him. The government
yes.
He was in BGR also. Yes. Then Malas, please kindly have our rejoinder to OP4.
Yes.
And kindly have Malas paragraph 13 on page 7.
Yes.
May I read this para, Malas? This is important for us. In reply to a Vermans in para 10 of the additional counter affidavit, it is submitted. Does the Lordship have that? This is the rejoinder to the additional counter affidavit. To OP4.
It's not there. Reply affidavit filed on behalf of OP.
No, Malas, our rejoinder, the petitioner's rejoinder to the additional counter of OP4.
On
Could you please give the date?
17.
Filed on 21/10/2024.
17.
21 was day before.
No, no.
It can't be.
Cannot
Day
be
before.
there.
I received it on 21.
No, no, 1710.
Date is not here.
1710. 17/10/2020.
Is it possible?
But I'll request my colleague to tender the hard copies if it's possible.
Rejoinder, your Lordship wants.
Let us see, just for the purpose of our understanding the issue.
Our reply to this was on 21st. Not this is 17th.
You filed a reply to the rejoinder to the additional counter affidavit.
Yes, that was filed.
Is there any end to?
No, this was filed second time also.
Earlier, there was a reply to your rejoinder also.
Yes, that's what I'm saying. That is why this is the copy which you have received from.
The additional counter is self-contained or that we have to read in addition to the earlier,
Self-contained.
so we can keep out of the earlier counter file.
So certain additions are there. Because
Which paragraph you are referring to?
because every time they file an affidavit, something extra is there.
Paragraph 13.
On page 7.
Yes.
That in reply to the averments in para 10 of the additional counter affidavit, is submitted that the opposite party 4 has no right or authority to interpret terms of conflict of interest to suit its undue advantage of retaining the contract secured by the arbitrary and illegal disqualification petitioner and other bidder at the cost of about 6,000 crores. The case of the petitioner that conflict of interest affecting bidding process is relevant to render any bid submitted by prospective bidders disqualified. In this context, relevant to note that opposite party 4 is also situated in similar position, being a joint venture partner with BGR, another bidder disqualified, executing contract at Magadh OCP of OCL as a joint venture, which association according to MCL does not qualify to be termed as conflict of interest for reason that joint venture partners do not have a relationship and that the lead partner is responsible for the operation. If such contention the MCL is accepted, it is duty of MCL authorities evaluating the bids in the contract to give reasons as to how participation by petitioner in BGR affected by bidding process, especially in the absence of participation by a joint venture company, so and so and so and so, which were incorporated in terms of respective tender conditions and which will be sole purpose of executing these contracts in specific that are awarded to consortium joint venture. So therefore, Malas, please note, the opposite party 4 is also in joint venture in a prior project with the BGR, which is the other disqualified bidder, in a contract called Magadh OCP. So what's good for the goose has to be good for the gander. If I am sought to be disqualified as having an association in an SPV, surely the OP4 also is disqualified. Now, this factum is not contradicted in the reply filed to this rejoinder by us, so-called sir rejoinder by OP4. So this is an admitted fact.
Yes.
We have not filed any reply to
This is not a, no. We'll see, Mr.
Yes, yes. What could this rejoinder?
All right. Yes.
Now, Malas, please also consider, while referring to Malas an associate, within the meaning of Malas subpara 5 of the conflict of interest, the associate is relevant for the present contract. Now, in our present contract, I don't have an associate. I am a single sole bidder. So is BGR.
No, therefore the conflict of interest.
I'm
Had
sorry.
you participated together, the matter would have been different.
Yes.
But you are competing with each other.
No, what I'm saying is this, Malas, that as subpara 5 works, Malas, I could also be disqualified if my associate has, Malas, a shareholding of the other bidder. My most humble submission, firstly, is that I don't have any associate in my bid here. I could have an associate, so therefore I could, Malas, give not a sole bid, but a bid along with an associate. So subpara 5 would disqualify that associate. But even assuming, Malas, we interpret it in the fashion that an associate could be outside the present bid. That associate, again, Malas, is strictly qualified in terms of subpara 5. Please kindly, I'm so sorry, Malas, we come back to subpara 5, the disqualification provision. On page 58.
Yes, please.
Please read, Malas, such bidder, member or associate. So let's first concentrate now on the associate. Or an associate thereof has a relationship due to ownership, holding, cross-holding with another bidder. I pause here. So therefore, my associate has a relationship due to ownership, holding or cross-holding with another bidder. Now, they define what an associate is in 2.2.4, which is 2 pages later.
Yes.
Please have 2.2.4 associate subpara 2. For the purpose of this expression, associate means, so the associate here is the 2 SPV companies. So it reads, for the purpose of this RFP, the expression associate means in relation to the bidder, which is me, a person who is controlled by the bidder. As used in this definition, the expression control means with respect to a person, which is a company so-and-so, a right to appoint or cause appointment of more than 50% of the members on the board, or ownership directly or indirectly of more than 50% of the voting shares of such person. So therefore, please note, assuming the 2 SPV companies are my associate, in terms of subpara 5, the disqualification is that associate has a relationship due to ownership, control, ownership, holding or cross-holding with another bidder.
Yes.
This again does not satisfy the requirements of subpara 5.
Yes.
Now, please kindly consider one other factual averment is the nature of the price bids.
Yes.
R4 OP4's price bid is on page 216 of the petition, annexure 7.
Yes.
At a rate of 568 per unit. Total being 15,510 crores over the term of the contract. While the petitioner's bid is the rate of only 434.50 on page 217, and I am cheaper by over 3,000 crores.
Yes.
And 218 is an adjoining mine where the rate is 497.
Yes.
So therefore, only showing OP4's bid is far in excess of both my bid as also the bid for an adjoining mine.
Yes.
That's all. Now, please kindly consider how your lordships have construed the interpretation of such provisions. And just a few precedents at that. One view from the Gujarat High Court Division Bench in the matter of aquafill polymers. Well, my colleague will just hand over copies, physical copies.
Yes, what is that? What is there in the...
The principle, of course, is that any provision of disqualification provision must be strictly construed.
Yes.
And the relevant paras are 5.2 and 5.8.
Yes. Yes. Yes, we accept your.
Yes.
We accept your this contention that any disqualification provision has to be constituted strictly.
I'm so grateful.
There cannot be any
I'm
dispute
so
over
grateful.
this.
I'm so grateful. Then, may I just place the construction of a similar provision by the Bombay High Court in the case of Harsha Construction.
Yes.
Now, please kindly have this judgment, which may have some relevance, Malas. And if Lordship has internal page 26, the paging is on top, which quotes the provision at the bottom of that page.
Yes.
Please have Malas under the head of clause 4.2 at the bottom, conflict of interest.
Yes.
A bidder may be considered to have a conflict of interest with one or more parties in the bidding process if they have controlling partner in common, receive or have received any direct or indirect subsidy financial stake from any of them. And then please kindly have the underlined part, which is para D. They have business relationship with each other directly or through common third. Merely because we are SPBs in a prior or different project cannot lead to the assumption that we are partners forever and there is any sharing of information.
Mr. Sethi, what was in dispute before the Bombay High Court? Was it a case of blacklisting or what?
No, they also found this was a case where a conflict of interest provision was invoked.
On account of having business relationship with this.
Which you also find, Malas.
All right. Yes.
In paragraph 5.
We have seen that.
I'm so grateful. I'm so grateful.
Is that all, Mr. Sethi?
Well, just one other provision. Just well, it's just a recent view of the Supreme Court in the case of Bansidhar versus Bharat Coking. On the principle, Mala, that even if the contract has been awarded, in the meanwhile, while our challenge was pending, will not restrain the court from setting aside the award if it also finds favor in our contentions. That's paragraph 29. on page 24. The submissions made by the council respondents of the project in question being infrastructure and also one of mega project, this court may not interfere, more particularly in view of the fact that the agreement has already been entered into between respondent BCCL and special purpose vehicle of R8 cannot be accepted when we have found that the impugned decision of BCL was grossly arbitrary, illegal, discriminatory. As heard earlier, the government authorities are expected to act in absolutely fair, reasonable, transparent manner, particularly in the world of contract mega projects. Any element of arbitrariness or discrimination may lead to hampering of the entire project.
Yes.
Therefore, if you also found my favor, mainly because the contract has been awarded, would not must come in the way of grant of relief. So, Malas, in conclusion, my most humble submission is, Malas, that the conflict of interest provision, Malas, does not arise in our case. There is no shareholding, Malas, of BGR in the petitioner company or vice versa. An SPV with by the two of us for a prior earlier project is not a matter of conflict of interest.
Yes.
This Malas manifestation is clear now from the new NIT.
Yes.
As also, Malas, the conduct of the department qua BGR, when in the face, Malas, of there being in joint venture with BGR, is found not to be a conflict of interest, and the present contract is awarded to them, and surely, Malas, that will be an estoppel against them for their understanding of the provision of conflict of interest. And of course, Malas, the public interest in the saving of 3,000 crores in considering my bid, Malas, as a qualifying bid. Malas, we have also, Malas, penned down, Malas, as written submissions of what I have sought to submit before the court. I'll request my colleague to pass them to you. I'm so grateful, Malas, for hearing. Most patient. I'm so grateful.
Yes. Have you given him a copy?
Just.
Yes, so is for the other case.
Let's humble submit this minutes. They may have to argue this case minutes. Mine is entirely different. Grounds are different, and even pagination, everything is different minutes. That's why once they do that one, that will come.
It may not be.
Yes,
That may not be the case. There are two bidders. On the last occasion also, they continuously argued. Actually, as a matter of fact, they cut the throat of each other, which they, as far as they do not want to do it, and I leave it to as it is. Otherwise, two persons, they participate in the tender. They are the petitioners. The clause is almost identical, which has been invoked, and they can't put us in a position to know our defense. They have to complete the answer.
No, there is the question of disclosing defense or everything has been disclosed in the counter affidavit. The question of interpretation.
The interpretation. Whatever the interpretation, let them do it. We'll answer it. Because they have to complete.
No. It's the
same tender. Same tender.
There is same tender. There are two cases. And counsel has concluded his argument.
Yes.
Now he wants that he shall argue after you finish your submissions the first case. Because in the first case, submissions have been made. You just respond to the submission.
Same argument later.
We don't know.
Yes. Again, it's a multiplicity of arguments again have to address on the in respect of the other person. See, comprehensively I can conclude There's nothing much to be done beyond that. Otherwise, one argument I have to address on behalf of this particular entity against the same person, same tender process, other person has been disqualified, same clause has been invoked, and later he wants to argue. This
But I'm going to just a
minutes. If at all they feel it the same thing, they need not argue the second time. They can simply say that we have already done it. Millets, my lords may can appreciate. They may not have that personal knowledge. When it comes to millets, the honorable judges writing of a judgment. Millets here.
Please come out of.
I'm coming, millets. Millets, I'm submitting.
That
they have referred to.
See, how will we write?
No, millet, I'm not on the point. The difficulty that I face and my lords may face and they also face, millets, I'm submitting. Millets, there is an entirely different pagination, different grounds. And we have got it. Millets, even both of us don't sail together. We have got different grounds to argue.
Pagination is not at all important. Important is the issue involved.
Yes, ma'am.
So if the issue is common, if the ground for disqualification is the same, then you can begin.
As far as I am concerned, millets, we have taken a specific plea.
All right.
I cannot be an associate because my percentage low.
All right.
Theirs is higher.
All right.
That's why my friend has said that we have tried to cut each other's throat.
We are requesting you to start your
I am more than willing. It's not is the question of request. I am more than willing. I have only submitted. This is how things are.
All right.
That if they argue, things would be clear. But if you not indicate that I should argue, I'm straight away arguing.
Please begin because please begin. Yes.
There cannot be any second thought on that, millets. I'll just straight away begin.
Yes.
Millets, the first respondent floated a global tender on 17/11/2022. My lords could see that at page 70 of my writ petition.
Yeah.
Millets, I submitted my bid on 16/2/2023 that my lords could see at page 49.
Yes.
Millets, the first respondent found 3 responsive bidders and they opened those bids for technical evaluation on 18 February 2023 that my lords could find at page 50. Kindly come to page 50, millets.
Yes.
Could my lord see page 50, millets?
Yes, please.
Millets. And then kindly come to page 51.
Yeah.
This was on 15/5/2023.
Yes.
This is the evaluation and the rejection of my bid as well as that of the other petitioner. It's one-page order, millets. My lords may kindly have it. The tender committee has examined the scanned copy of documents uploaded by the bidders in support of the eligibility against each qualification criteria to their response in technical parameter sheet TPS as per clause number so and so of RFB of NIT 179. The status of bidder after techno-commercial evaluation or as under. Name of the bidder eligible for price bid opening or rejected. VPR Mining Infrastructure Private Limited, eligible for price bid opening. The bids of the following 2 bidders have been disqualified, having a conflict of interest as per clause number 2.2.1b of RFB declaration under point number 5 of bidders covering letter and acceptance of bid conditions and under clause number 2.6 of RFB and rejected under clause number 4.1 of RFB due to directly or indirectly engaged in undesirable practice as defined under clause number 4.3.d. Millets. Finally, millets, my lords could see bid security EMD deposited by these 2 bidders, NCC Limited and BGR Mining and Infra Limited, during bid submissions forfeited as the damages as per clause number 2.2, etc., etc. The price bid of eligible bidders will be opened on 15/5, so and so. Now, millets, my lords may kindly come to the next page. This is the one, millets. They have opened financial bid opening summary of NIT. This was also on the same day, millets, on 15th May And that's been indicated, the figures. My lords have seen that one. Kindly come to the next page, page 53.
Yes.
When they put me on notice, my lords, immediately I respond to this one. On the question of disqualification, my lords, may I just read, my lords, with reference to the above, we would like to inform you that we have participated in the tender floated by so-and-so for the work mentioned in the NIT document referred to above. In view of the technical bid opening on so-and-so, and also as per website information, there were 3 participants, namely so-and-so. The aforementioned tender has not yet been finalized by MCL. However, in the meantime, we were informed that we, BGR Mining so-and-so, are disqualified in view of clause 0.2.21b of RFB, stating there is a conflict of interest. The exact reason mentioned in the website MCL is extracted below. The bids of so-and-so, so-and-so, which I've read earlier. Millers, in the said context, we would like to inform you that there is no conflict of interest as stated by so-and-so. This is the defense we have given. We have extracted the clauses and everything. Then, Millers, Ashoka's notice was followed. Thereafter, wordsmiths, the writ petition has come to be filed. Millers, kindly, in this context, when we filed the writ petition, they filed a counter. I would like to take your lordships to that counter before I could analyze these clauses, which they say come in the way, we say may not come in the way. In that context, Millets, how the clauses were understood by the first respondent. For that purpose, Millets, kindly have a look at the counter they have filed. Millets, kindly come to.
Yes.
Let's kindly come to page 2 of the counter.
Yes.
Millets, it simply deals with the maintainability. So that I will not trouble your lordships with that one, Millets. And in page 3, they say, Millets, no judicial scrutiny of NIT conditions. And Millets, they also say, since the other 2 were disqualified, the question of comparison of any price would not arise. Then, Millets, they also say that on remand, we are trying to expand the scope of the writ petition. Then, Millets, they talk about the tender, the documents, and the stage, etc. I need not trouble your lordships on that count, Millets. Kindly come to page 7. Here, they talk about the provisions. They also extract the Millets copiously.
Yes.
Let me go, Millets. Then they say, Millets, at page 9.
Same affidavit, almost.
Indeed, Millets, page 9.
Yes.
My lords could come. They say how they have unearthed in a Sherlock Holmesian fashion that there is a conflict of interest. They say that, Millets, first, there is one Singareni Collieries Company Limited. There we are the other petitioner. Second, there is, and the third one, they said, Millets, this is Pachwara Coal Mining, PCMPL, Millets. Here they say that NCC has 51% stake and we have 49% stake. So, Millets, kindly come to para 8 here. In that one, the subparagraph.
Yes.
The work experience submitted by NCC Limited at serial number 3, as shown in the above table, is that of its associate. An associate has been defined in clause 2.2.4(2) of the RFB. It's humbly submitted here as per clause so-and-so. In computing the technical and financial capacity of the bidder, the technical capacity and financial capacity of its associate would also be eligible, and a bidder is permitted to submit and rely upon the experience of only one associate for the purpose of qualification and eligibility and RFB. If I am given to understand Millets correctly, what it says is that, yes, if you're an associate, your experience will also inure to their benefit. Since you're an associate, one associate can be taken. Could have been the implication. Millets, my lords would be deciding that one. Then Millets, they extract the clauses. kindly come down, Millets. After all these things, Millets, they have come. They have also said in para 12 about the share pattern between us, para 12, page 12, I beg your lordship's pardon, page 12, my lords could see that they hold 51%, we hold 49%, and Millets, in para 10, they say this has led to, may I read Millets? Fifth line.
Yes.
It's fresh certificate of incorporation consequent upon conversion and private company to public company issued by ROC, Hyderabad. In view of the above, the tender committee got an impression of suspicion on this two bidders, NCC Limited and the petitioner, as they both have participated in this tender individually and seem to be connected through a common third party, that is Pachwara Coal Mining Private Limited. Therefore, tender committee visited the provisions of the tender documents for this e-tender, invited so and so, so and so. This is what the crux of their whole defense, Millets. Thereafterwards, Millets, my lords may kindly come to page 14.
Yeah.
Millets, here in para 12, they say that, Millets, when it comes to this SPV, there are common directors, etc. Millets. The fact remains my director quit in 2018. That apart, Millets, they say that, yes, that's what we have got, we have gathered. Then eventually, Millets, in page 18.2, they repeat the same thing, Millets, that we have got the directors, they may have contacts with each other, etc., etc. Thereafter, Millets, kindly come to page 20.
Yes.
They just give the replies, Millets.
Yes.
Interesting, let's kindly come to para 20, page 23. Second para, Millets. It's humbly submitted that here that as per clause so and so, the reasonability of L1 price and the viability of the project for the authority on the price quoted by the L1 bidder were ensured. The tender committee engaged so and so, the technical advisor consultant of the opposite party number one, for the viability study report of Balabhadra OCP at L1 bidder's revised offer price. Tender committee, upon going through the viability prepared by its technical advisor consultant, observed that the Balabhadra project is viable for this L1 bidder revised offer price at 532. List pendants, Millets, when we have been vying that, we have been, though L1 had been sidelined, now Millets, to ward off any adverse consequences on their own, the second respondent revises the bid. Even then, to this day, they could not match us. That's a different story, Millets. At least they have had an afterthought to do that one. Millets, kindly come to Millets, page 24. Para 21, they say we have gathered from the public domain that this is the information and there is a conflict of interest. My lords have seen and pertinently pointed out as well that they could have sought clarification, but of course it is discretionary. And instead they have just indulged in guesswork, and we have pointed out later saying that, look, not only as I've had an association, as they put it, with the other petitioner, I have also had the same association with the second respondent as well. Then Millers, their answer is that, yes, you have, but that project was closed. Good enough. Then Millers, I have pointed out, not only that project, there is another project as well, and there's no answer on that one. Now Millers, as an afterthought, they come before your lordships and say, yes, there is a project, but it's only a consortium, not an SPV. And that's why Millers, my lords, now will come to the interpretation whether such hair-splitting technicality would come to the rescue of the respondents, and then Millets, whether the purpose behind such a condition of not having conflict of interest is to prevent cartelization. Once it is to prevent cartelization, and then Millets, in what capacity one associates with the other, and if in a strict interpretation to be given to those clauses, such a distinction could be maintained is the only thing before your lordships. Either we stand on the same footing and survive based on our competitive bidding process, or we may perish because we have on the grounds. But they would like to rescue themselves on this principle. Yes, we have all had, but this is the distinction they have. For that purpose, Millets, finally, before taking to the clauses, may I just take your lordships to my recent reply to their counters, Millets? My lords could have that one. When was it filed? Millets, it was filed on 8th October.
The rejoinder reply.
Millets?
How have you refined your pleading? The rejoinder reply affidavit.
Millets, it's been styled as rejoinder affidavit, filed on 8/10/24.
360.
The rejoinder affidavit filed on behalf of the petitioner to the counter.
It's in response to the counter filed by the opposite number 2, Millets.
2, yes.
Yes, Millets. That way I filed, Millets.
I got it. No, that is not possible.
My lords got it?
This is 23/6/2023.
No, Millets, I'm afraid this is 8th October 2024.
That nomenclature is rejoinder affidavit on behalf of the
Petitioner.
The additional reply affidavit filed by the
Got it.
party number 2 dated 10/9/2024.
Internal 429, digital 583.
Yes, all right.
My lords got it?
Yes, please.
Yes, please. Kindly come to page 6, Millets.
Yes.
Millets, para B at the bottom.
Yes.
That it submitted that opposite party number 1 authority itself has made no distinction between JV and SPV while applying the conflict of interest clauses in RFB. The same is clearly borne out by a plain reading of its letter dated 18/5/2023 addressed to GM CMC Northern Coalfields Limited of the counter affidavit filed by the opposite party number 1. It is submitted that in the said letter, the opposite party number 1 has inter alia put the following query to the GM CMC Northern Coalfields Limited. Is there any ongoing project? Millett, this is in the context of the second respondent. Is there any ongoing contract in Cardia project or any other project of MCL as on 16/2/2023 formed between BGR Mining and Infra Limited and VPR Mining Infrastructure Private Limited as JV Consortium SPV? It's been said, Millets, whether it could be a JV, it could be a consortium, or it could be an SPV, but please let me know whether such a thing is there. The answer was, Millets, the answer was, it was there, but that was closed. Millets, then we have informed them, if this is the case, there is another project which has still been continuing. And they have not adverted to that one. That's why, Millets, either we stand together, we sing together or sail together. In that context, Millets, they have said, is there any joint venture? Is there any consortium? Or is there any SPV? Now, Millets, to illustrate their conduct, kindly come down, Millets, at page 9.
Yes, please.
8 bottom, Millets, para G. 8 bottom para G that provides the backdrop. My lords could get that one.
Yes.
Millets. That it's a matter of record that all the 3 bidders, namely NCC, BGR, and VPR, have on various occasions entered into JVs or SPVs for the purpose of executing specific projects. Simultaneously, these entities have also independently competed against each other in various tenders floated by subsidiaries of Coal India Limited during the past 5 years, as detailed here in below. My lords, may kindly see here, Millets. The first one, the same first respondent.
Yes.
The first one, Millets. All 3 of us participated. I was L1, VPR L3, second respondent L3, and the other petitioner L6. No objection, no conflict of interest. Then, Millets, this is another subsidiary, the second one, BCCL. I was L1, the other petitioner L4. The second respondent was not in the picture. Then comes millets, the second one, the third one rather, millets. This is NCL, another subsidiary. We three were there. Thereafter, fourth one, again the same entity, that is the first respondent. All three of us are there. No objection. Then millets 5. Again, millets, another subsidiary. 3 of us are there.
Yes.
Millets, they did not, the same conditions, same thing, they have not. And my lords could see on all occasions I was L1. Perhaps they got frustrated, they could not have it. This time they had it with a technicality. And my lords may examine whether that technicality really comes to their rescue. It could be seen that millets, the same conditions, just before, a year or two. One is just 1 year ago. Millets, then millets, para H millets, then I'll come back to the conditions. That it's a well-established practice in the industry for entities to form JVs or SPVs for the execution of particular projects while also competing independently in other unrelated tenders. The mere existence of such JVs or SPVs between bidders without any cogent evidence indicating collusion or exchange of sensitive information cannot be construed as a conflict of interest. In the absence of any proof that one or more of the bidders had access to or influenced the other's bidding process, such a relationship is inconsequential to the present matter. Millets, when it comes to the earlier submissions, millets, it's been said with regard to they're seeking clarification. It assumes, in my humble submission, some importance for the reason, millets, the tenders have been floated and the bidding is through online. When I bid, I don't know who are going to be the other bidders. Had it been a case of my knowing that beforehand, or for that matter, any of them, any of us, then I could have to disclose if there were to be anything. We don't know who is going to participate, who is not going to participate. Then, millets, once the participation is there, once they shortlist, then only we'll come to know who are the players. Then, millets, if they feel that there is any information clarification to be sought, that could be done. Without our knowing it, it only begs the question at the time of my filing online, without knowing my rival, that whether that rival has anything to do with me or not. That's why, millets, that clarification assumes importance in my humble submission. Now, millets, I'll come back to the brass tacks, how the clauses need to be interpreted. I'll just come to that one, millets. Millets, may I take your lordships to the clauses, millets? Kindly come to page 99.
Yes.
Eligible bidders, millets. 2.2.1. Millets, this is in my writ petition.
Just. Okay. Digital page, any idea? 247. Yes.
May I just read, millets? 2.2.1, eligible bidders, A. Bids may be submitted by a single bidder or a consortium formed by a maximum of 3 members, which satisfy the qualification criteria stipulated in the bidding documents and has a DSC issued from any agency authorized by the CCA, and which can be traced up to the chain of trust to the root certificate of the CCA. Where the bidder is a consortium, it shall comply with the conditions set out in clause 2.2.7 below. Millets, what they've used against me to begin with is, millet, this clause B. My lords, may kindly see that. A bidder shall not have a conflict of interest that affects the bidding process. That affects the bidding process. Any bidder found to have a conflict of interest shall be disqualified. In the event of disqualification, the authority shall be entitled to forfeit and appropriate the bid security or performance security, as the case may be, as mutually agreed, genuine pre-estimated loss and damage likely to be suffered and incurred by the authority, and not by way of penalty for inter alia, the time, cost, and otherwise. A bidder shall be deemed to have a conflict of interest affecting the bidding process if, now my lords may kindly see, the bidder, its member or associate or any constituent thereof, and any other bidder, its member or any associate thereof or any constituent thereof, have common controlling shareholders or other ownership interest, provided that this disqualification shall not apply in cases where the direct or indirect, let's come together wrongly, direct or indirect shareholding of a bidder, its member or an associate thereof, or any shareholder thereof having a shareholding of more than 5% of the paid up and subscribed share capital of such bidder, member or associate as the case may be. In the other bidder, its member or associate is less than 5% of the subscribed and paid up equity share capital thereof, provided further that this disqualification shall not. The rest is not necessary, Millets. What's been said here, Millets, the sentence could have been split and could have been made more explicit. Instead, Millets, it's a convoluted one, leading to a bit of a confusion. What's been said, Millets, the bidder, or it could be the bidder's member, its member, or its associate, if they have something to do with its counterpart, another bidder, etc., then they are disqualified. But if they have less than 5% stake in the other entity, they are safe. This is what's been said, Millets. Now let me come to the other clauses. Kindly see Millets BB. Subject always to subclauses so and so. It will not affect us. That's why, Millets, we need not trouble your lordships with that one. Kindly come to subclause 2. A constituent of such bidder.
What is this AA?
Millets?
AA. What is subject always to subclause AA? Where is AA?
It's 5 lines above.
Millets.
5 lines above.
Millets. AA. Where any intermediary, may I read that, Millets?
Just a minute.
In 1, kindly come to the last, Millets, before BB. Again, it was clubbed, it should have been separated.
Should be for the purposes of clause 2.
Millets, kindly come to page 99.
BB we are seeing, but where is AA?
Just above BB, Millets, just above BB, 5 lines. Just above BB, 5 lines.
The right.
All right.
There is enconced, that AA.
All right.
My lords could see that one.
All right. Yes.
Where any intermediary is controlled by a person through management control or otherwise, the entire shareholding held by such control intermediary in any other person shall be taken into account for computing the shareholder.
Have been in the next line.
Beg your pardon. It should have been in the next line, precisely.
But in fact, your lordship go up 1 line for the purposes of this clause. It has to be read from there. A and
may I read, Millets, so that it could be clear?
That we have seen.
Yes.
This is for the
purposes of this clause.
For the purposes of this clause, indirect shareholding.
Precisely.
Held through one or more intermediate persons shall be computed as follows. There are 2 conditions, AA and AB.
Lordship.
So that should have been in the second line.
Please.
Yes, Millets.
That is the material.
Millets, to avoid an allegation against me that I've read in part, may I read that the whole thing, Millets?
No. All right. Yes.
Because I felt that Millet doesn't affect any of us. And I've just focused on, because they've said their talisman is class 5, subclass 5. I'll come to that one later. Now, Millets, kindly see subclass 2.
Yes.
A constituent of such bidder is also a constituent of another bidder. Or 3. Such bidder, its member or any associate thereof receives or has received any direct or indirect subsidy, etc. Then Millets 4. Such bidder. Millets, what's the common refrain here is, Millets, such bidder, such bidder, such bidder. If you lords could see, Millets, this 2.2.1 B begins with a bidder. An unknown entity,
such bidder.
An unknown entity. Then Millets, kindly see, Millets, B1 uses the expression the bidder. And it gives who that bidder can be, or whose its member can be, and who its associate can be. By stating that if you have any stake in the other entity who is also a rival competitor, and if you have less than 5%, the benefit they may get by cartelization, whatever, may be minimal. That's why you can as well have it. If you have more stake than that one, then you are perished. Then, my lords, the rest of the clauses talk about the interplay between these two persons. It could be bidder and bidder, or associate and associate, vice versa, whatever. So that's why, my lords may kindly see the expression, my humble submission, all beginning from 3, 4, 5, and 6 millets, such bidder, such bidder. Such bidder only refers to the bidder in 1B, where that limitation has been imposed or its nature has been prescribed. That for that purpose, millets.
It's like a bidder, the bidder, such bidder.
Such bidder. Millets may just lexically show your lordships a definition from the shorter Oxford English Dictionary, which is 2-volume dictionary, where such in what context and what meaning it imparts. My lords may kindly have it, millets. Anyway, I'll be giving a copy to your lordships, millets, but let me read that one. Millets, originally Oxford English Dictionary, 21 volumes. And that's been condensed for the public use into 2 volumes. And millets, thanks to these technology, millets, they are available as apps. We can buy and keep them anywhere. And that's the app, millets. Here it says, I'll provide the copy of this, millets. Such, it's among other things, a demonstrative adjective. And it says, of the kind, degree, or category previously specified or implied contextually. Proceeding the grammar. Second one, millets, of the same kind or degree as something previously specified or implied contextually of that kind or similar. My humble endeavor before your lordships is that, millets, when it comes to these clauses, they have to be read conjointly under the flag of 2.2.1b. Once 1b leaves me from the scope, the rest will not affect me. Because I am not such bidder, the bidder of that nature. That nature is my having 5% stake in the other entity.
Yes.
So, millets, once I am out of that mischief, otherwise, millets, they could have had that disjointedly, saying that either that could be, or this could be, or this could be, and the bidder could be whatever. But they have said that such bidder as described in 1b. And that's why, millets, even the dictionary says either it could be a reference straight or by implication, because there is a particular type described, not every bidder. Now, millets, kindly come to subclause 5. Millets, at page 100 I am.
No, but it is not very difficult, Mr.
Yes, millets.
C.
Yes.
The clause 1 says,
yes.
B says a bidder.
Yes.
Shall not have conflict of interest.
Yes.
Then,
and millets,
B1 says the bidder.
The bidder, and it gives
its member.
The relationship with the other bidder. Millets,
yes.
We may have here.
When it says
yes.
B,
yes.
a bidder,
yes.
Then in B1, it says the bidder.
The bidder.
Since it refers to a bidder,
it
becomes the bidder.
Millets, a bidder should not have any conflict of interest. Any bidder. Simply put, millets, first thing says, any bidder shall not have any conflict of interest. That any bidder could be exempted from this clause, provided is out of this mischief. What B says, millets, that bidder who should not have conflict of interest can be exempted. Yes, millets, please.
See, this will have to be read like this. A bidder
yes.
shall not have a conflict of interest.
Precisely.
Then come to the last sentence
yes, millets.
Of the B.
Yes.
A bidder shall be deemed to have a conflict of interest affecting the process.
Yes.
If the bidder.
Yes, exactly.
So it
so
refers
that
to
particular
a
bidder,
which becomes the bidder.
Millets.
And then it says such bidder.
Yes, I'm coming to that, millets.
Yes.
Now, what's been said, millets? The one who has bid may have faced an allegation that he has a conflict of interest. Then the rest of the clauses say when you will have a conflict of interest, when you will not have a conflict of interest. What's been said, millets? It only talks about, millets, this one talks about the exception. Who cannot be, though a bidder, who cannot be accused of conflict of interest. This is an exception. And that exception comes into picture provided his interest in the other bidder is less than 5%. This is what's been said, Millets. And if at all I have less than 5%,
Yes.
then the rest of the condition only refer to that bidder. Either that bidder could be having more than 5% or less than 5%. If I am more than 5%, everything attracts to me and then I perish. If I don't have such a stake, then I will not have. Of course, Millers, they fulcrum, at least as far as first respondent is concerned. They say it is not bidder versus bidder or bidder in relation to another bidder, but you both have an associate. That's what their contention. That's where, Millets, associate has been defined. Kindly come to that one, Millets.
Can we continue in the second? Should we? Otherwise, we are sitting single.
Yes. That's what I was actually also thinking we are discussing. There was one unforeseen circumstance which is predicted.
Yes.
Therefore, actually, we had planned actually, we had to review early, otherwise the flights are likely to be cancelled. That was the indication.
So, flight has been cancelled.
No,
likely to be cancelled once it is hit.
So when is your flight?
Evening,
So,
5 o'clock I have to.
so can we continue at 2 or?
Instead of that, any matter will not be concluded today. So, because we have to argue, then rejoin us, definitely it has to
All right, then we can.
Lordship, but to continue, my lord, it may not finish.
finish.
Even
It
if your
will not
lordship were
finish
to
today.
continue, my lord, it would not finish. So therefore, my lord, that's the prayer.
So,
being.
any date with concern of all of.
Any date after Diwali, Wednesday, Thursday.
During Diwali, Millets,
good.
my lords will be working and we'll be on holiday. Could it be next Wednesday, Millets? So that it will be fresh in your lordship's memory, nothing else.
So don't put me during Diwali, Mr. Naidu. This is my personal request.
No, I will not come in.
We have also code.
Oh, but Wednesday?
Wednesday is the last one.
Yeah.
Wednesday is there, but we have also
Wednesday, Thursday.
Thursday, Friday, Saturday.
After Diwali holidays.
Immediately thereafter, Millets, subject to your lordship's board.
I don't have. We don't have any
Fifth.
issue.
Mr.
5th of. 5th is what?
6th or 7th it comes in.
6th.
No, sixth Millets, 6th.
PM is not available unless. we
6th,
don't
no,
sit.
we shall finish it on 6th.
So wait, Millets, 6th.
6th.
So 6 2 PM are okay.
6th, 7th. 6th or 7th.
6th.
Whatever.
Single bench are okay.
6th, let it be, let it retain its position on 6th.
Indeed.
If required, we shall continue after recess.
Millets. And we'll plan even to stay the next day so that they will not win cyclone then.
Lord, could it be 7th, my lord, if I may request you?
7th, what, how will that
Thursday.
help you? Thursday, no, let it come on 6th, Mr.
Millets, we could
There is
finish, my
reason
friend
why.
could have on 7th as well. We'll
There is
stay.
a reason why, because on 7th, see, we have so many old matters pending. And therefore, we have fixed Thursday for taking up old matters.
Lordship.
So let it come on 6th.
Very well.
We will try to finish it. In the second half, we can sit
Sure.
if required.
Please.
And if further required, we can special case take up this matter on 7th also.
Great.
Please.
Great.
Very obliged.
All right.
Yes,
So,
great.
as third one, for further hearing, list these matters on 6th, retaining its position.
Item number 21, maybe.
Mr. Mohanty, you were making a mention.
26, that national highway matter.
Yes.
Can it come on at least, taking up old matter tomorrow? Day after tomorrow, 28 or 29?
28 within first 5 cases.
Item number
Can you
The next matter, item 4, you'll ask that
2 PM.
Within first 5 cases, Mr. Mohan. Your case will be taken up within first 5 cases.
The next matter, my lord, you're also take first 5. Any date, you're on. That hotel is closed and lots of data. Any data subject to a
Monday.
But item
No,
number
the item
21, my lord.
25,
Item number
27.
21.
What do you want?
21 today, please.
What do you want?
Or it may be taken up any convenient date because matter is urgent.
Urgent. You can make a mention on Monday. You can make a mention on Monday. We'll try to take.
25 and 27. May I pray next week?
Monday there are.
Item 6, item 6.
25, 27.
Item 6.
Lords, may I mention item 19, it is part heard. Yesterday it was heard by the Honorable Court. So can it be merged taken?
All the cases shall be listed on Monday, and any urgent matter can be mentioned in the morning. So if the matter is so urgent that it is to be taken up, we will take up such matters on Monday.
Item 19, my lords,
This one.
can it be maintained at its position and heard, my lords, as
Yes,
and when it
it will
comes?
retain its position. It will
Please,
be
please.
in a better position on Monday.
Please, much obliged.
Six. It will come on Monday.
Item 18,
It will come on Monday. Monday, make a mention in the morning.
Yes, admission item number 1.
Beg your pardon, Lord.
This is
I'm filing memo for modification of the order. In fact, in this case, the tribunal consisting of 3 arbiters should have been appointed. As per the general conditions of contract, the arbitration tribunal should have consisted of 3 arbitrators. We have proposed that, but inadvertently, sole arbiter has been appointed.
Oh,
I'm just praying for modification, Your Lordship.
me?
Modification, Your Lordship.
Sure.
Kindly be listed on 30th, Your Lordship.
13th.
Item 1, sir.
Item number 1 for Vera. Sir, my lord, actually, I was working in Auto one private organization from 12th November 2020 to 30th of November 2021. And there happened agreement with me, but after the tenure, they are breaching the agreement. There happened lawful agreement with the organization, but after the tenure, they are breaching the lawful agreement. So I need help here from the court. So I need help here from the court. Actually, my 6 month salary is pending with the organization. They are about to pay as per the agreement, but they are not.
You are in
so I
which
need help
case?
from the court.
You are in item number 1.
This is item number 1, sir.
So this is
Item number 1, Saurabh Shekhar Bera versus Auto 1. ARBP 79.
Where is the arbitration clause?
Arbitration, actually, agreement involved. Agreement is from page number 6 to page number 8. The agreement involved mentioning page number 6 to page number 8 of interlocutory application. One interlocutory application is there of interlocutory application number 8 to 8. That is arbitration. Arbitration agreement.
Page 8 of what?
Sorry, my lord.
Page 8 of what?
Page number 6 to page number 8 of interlocutory application containing the agreement.
Where is the arbitration clause?
Arbitration
This is
clause
item number 1.
Yes, sir. Item number 1.
What do you want?
Actually, there is a there was a lawful agreement between me and the private organization, and it was going on, but they are breaching the private organization. Some disputes came out in the agreement, and I want to resolve those disputes with this arbitration.
Where is the arbitration? There is no arbitration agreement at page 7 or 8.
Page number 6 to page number 8 of interlocutory application. Interlocutory application. One interlocutory application attached with the petition. Of that interlocutory application, page number 6 to 8, agreement W.
Page 68. Which page
Page
of?
number 6 to page number 8 of interlocutory application, sir. My lord,
IA 21 of 2004. IA number 21
Yes,
2024.
Yes, my lord.
You are
In that
referring to
interlocutory application, page number 6. I am referring to the interlocutory application attached with the petition. In that interlocutory application, kindly move on to page number 6 to page number 8 for the agreement W.
So where is the arbitration clause?
Arbitration clause in this sense?
Huh?
Arbitration clause in this sense, my lord. Meeting.
Arbitration clause in the sense that there should have been agreement that in case of any dispute, the matter should be referred to an arbitrator for resolution of the dispute. Is there any such clause in the agreement? Is there any such clause in the agreement? Where is that?
No. In the agreement, there is no such clause. The agreement happened as per the contract act of Indian Constitution. Indian contract of Indian Constitution agreement happened between me and the organization. And the disputes are
Mr.
now.
Vera, I am not able to understand what you are saying. See, there is an agreement between you and the other side, other party.
Correct.
You have filed this application for appointment of arbitrator.
Appointment of the arbitrator, that can be Chief Justice of
that can be done only if there is any arbitration provision in the arbitration agreement. Is there any provision in the agreement?
In the agreement, we can resolve the dispute which can arise in the any contract of Indian Constitution as per arbitration agreement clause of. Okay, my lord. That is section 2, suppose B of the Arbitration and Conciliation Act of 1996. Section 2, suppose B of
All right.
Arbitration
This
and
application
Conciliation
has
Act.
been
That
filed
is
for appointment of arbitrator under section 11(5) of the Arbitration Conciliation Act. However, there is no arbitration clause in the agreement on which the petitioner is relying. So this application is accordingly not maintainable and stands dismissed. Yes, next.
For orders, item number 2.
Item number 2, Your Lordship, I will file requisite within 10 days for filing of fresh notice. 10 days, Your Lordship.
10 days.
10 days, Your Lordship.
10 days plus notice. Yes.
Item number 3.
Item 3 also similar, Your Lordship.
Same.
Item number 4.
By the last order, your lordship said directed me to take fresh steps. Accordingly, I had complied with your lordship's order. Now the noting is, the AD is not back. Lords, may I submit one thing,
Awaiting service of notice.
What had happened during the pendency of this arbitration proceeding, my lords, my learned friend Mr. Arnav Das, who is appearing in item number 6, in fact, my lords, he had arranged for a conference between the parties so that if it could be settled out of court, but ultimately did not fructify, my lords. So what I humbly beg to submit before your lordships, my lords, if my friend can take instructions whether he can appear in this matter, then my lords.
I don't presently have any instructions to appear in this matter, but if there was we could try for a mediation in the process. If it may be referred to the mediation center also, that's okay with us.
No. Arbitration, he has filed an application for arbitration.
I'll see if I'll get some instructions. I have not been noticed.
Awaiting service report as regards service of notice upon the opposite party. Rest this matter on 2 weeks. In the meanwhile, you can file your.
In the meantime, let's let
that he can do. We will not indicate. I will not indicate.
Item number 5.
Here, your lordship had actually appointed Honorable Justice Anand Patnaik, but I think flag 10, he has indicated he is recused. The reasons indicated therein.
Flag?
Flag 10, I think. It appears from this display board. The flag 10. The more specific, it's at page 239. That I was also not aware as a counsel, and he has tendered a legal opinion. So for which
the order says, my lord, this is a claim, my lord, your lordship please to appoint the presiding arbitrator. Both arbitrator failed to nominate their arbitrator. And the then your lordship please to list of the my learned senior please to appointed former judge of Supreme Court of India, my lord. Then arbitration center it was registered the case and direct to party appear before this case. And the order sheet says which is supplied by the arbitration center because of fourth schedule he is refused, my lord. The order says, my lord.
That is what I'm pointing out. That is what I'm pointing out to my
regarding furnish the schedule V from fourth schedule. Similar any former judge of this court may be appointed because claim is within 20 crores, my lord.
My submission before your lordship on the last occasion was
Yes, very valid reason has been given.
Yes, yes.
That he had given number of legal opinions.
Yes, yes. Which was not within our knowledge, at least. It must have been
several mining matters.
My only submission before your lordship was on the last occasion that since he is appointed Honorable Justice Biswanath Rath, and our side we have appointed Samij, a consultant specialist in our matters. What I request is there should be a senior Supreme Court judge, Honorable Supreme Court judge, who can preside over the matter in a convenient manner. That was my submission before lordship. Now I leave it to your lordship because in my list.
Leave it to me then. Leave it to me.
Yes, that I leave it.
In fact, on the last occasion, I did not seek consent. So let it come on next Wednesday. I'll have consent and then appoint.
Also submit a list, your lordship, supplied my learned senior.
List you have submitted?
Yes, yes. Same list.
Of
this honorable court. Of this honorable court, who is a senior, all are senior to Mr. Justice B.N. Rottam.
I'll see.
Is your lordship, please.
See, I take my
yes.
And to assist your lordship, my suggestive list is at the top. The list of suggestive names.
I'll see.
That I leave it. We leave it to your lordships. The suggestive list contains the names of all the Honorable Supreme Court judges.
By an order dated 11/9/2024, Mr. Justice Anand Kumar Patnaik, a former judge of Supreme Court of India, was appointed as the third arbitrator under section 11(4) of the Arbitration and Conciliation Act 1996. My attention has been drawn to flag 10, from which it transpires that Mr. Justice Patnaik has not accepted the appointment on the ground of having given legal opinions to the petitioner. Petitioner is opposite to the opposite party in several mining matters. Several matters, man. Several matters. Let's stop. Does this matter on next Wednesday for me to decide a name for appointment of a third arbiter?
Deeply obliged.
I will not go by anyone's list. I may not.
As you lordship.
Item number 6.
Do you have any difficulty, Mr. Counsel, if someone in Delhi is appointed?
Yes, my lord, because my lord, as per my instruction, because the claim is within 20 crores, my lord. Generally, my lord, after the fourth schedule, they some
As such, there is no such notification with regard to any debarring, with regard to 24 crores, if it's not.
No, it's the convenience of the parties.
Convenience of the parties.
Yeah, we'll see. I'll see that.
And
I'll keep that.
in fact, to assist your lordship, in fact, the presiding arbitrator, when he enters appearance in the matter, they normally fix up a place as per their convenience. So that should not be an impediment because they can, parties can agree on that. That is not.
I'll see.
Item 6, I am appearing for the petitioner. In the last occasion, a notice was issued.
The instructions to appear, we have not received the notice, but I usually appear for the respondent, my lords. If a copy can be served on me, I'll take instructions.
Mr. What is your name?
That's Somya Mishra.
Somya Mishra and counsel generally appears on behalf of Grand Bazaar Developers.
Yes.
LLP. What's up? Let a copy of the arbitration of the petition be served upon him in course of the day.
Yeah. I'll do it.
First off, unless this matter on 2 weeks, so as to enable Mr. Mishra to seek instructions and take instructions of that.
Item 7. Please, Your Lord. Item number 7, my lord, pursuant to your lordship's order, we had filed requisites. It has come today that neither AD nor undelivered notice as against sole OP yet received.
Your lordships, I have instructions to appear for the opposite party.
What is your name?
Amlan Mahanti, your lordship.
State that he has instructions to appear on behalf of the opposite party. So, list this matter on. Do you object?
Your lordships, I have sought for instructions. I'll be submitting my response on
this matter on 2 weeks so as to enable Mr. So-and-so to seek instructions.
Grateful.
Obliged, Your Lordship.
Item 8.
My lord, item 8, I'm appearing for the petitioner through VC. My lord would kindly see the noting that the notice has been returned as refused. So it has to be deemed a proper notice. And my lord, I would suggest the name of Mr. S.S. Rao, senior advocate, to be appointed as the arbitrator, my lord.
Now, where is that? On the
office note.
Do you have his email ID? Email ID of the respondent.
Your lordship. Yes, my lord. My lord, that is there at page 14. Page 14, your lordship. I don't see that, my lord. No, my lord, I don't have it, your lordship. But there had been.
Okay.
May
Where is that office note?
It's not there, my lord. No, my lord, I'm sorry. I don't have the email.
Where is the service report? Huh? No, but where is that? Hmm? Hmm? Yes, email ID is there. No, email ID is not there.
That's refused. Lord, they have refused. The postal endorsement says refused.
So refused, therefore we don't know whether it was handed over to a valid person or not. A person who is not entitled to receive will not receive.
Well, it has gone on the registered address as per the agreement
Maybe.
that your lordship will see.
Take fresh steps. To its managing director, third floor. Who refused? Let first steps be taken for service of notice upon the opposite party. Processes, all the processes. Stop. In addition, the petitioner shall be at liberty to send notice to the respondent through email regarding pendency of this application. 3 weeks. Yes.
Gratefully, lodge.
Item number 9.
9, I appear for the respondent.
Item 9.
Steps.
7 weeks, 7 days time may kindly be allowed you also to file substitute attempts. Recently, I contacted with the son of that proprietor who has died in the meantime.
Yes.
Your lordship's last order indicates that the proprietor has died. So they need to take steps.
One, list this matter on 1 week so as to enable and counsel for the petitioner to take steps for substitution consequent upon death of the proprietor of the petitioner.
Item 10.
If I may please, your lordship.
Petitioner.
I'm appearing for the petitioner, your lordship. In accordance with the order dated 1st March 2024, the requisites have been filed, but it has been filed in a delayed manner. The same may be accepted, your lordship.
Accepted. Register, please. Yes.
Item 11.
May I please, your lordship? My lord, my prayer before my lord for appointment of arbitrator under section 11 of the Arbitration Conciliation Act. The arbitration clause is found place at page 48, my lord's brief. Previously, by order dated 25/9/2024, it has been ordered that despite valid service notice on the sole OP, no one has entered appearance.
My lords, I have instruction to appear on behalf of the opposite party. My lords, lordship may grant me 2 weeks time to file the wakalatnama and the objection, my lords.
Mr. State, what is your name?
Shaunak Mishra. S-O-N-A-K.
States that he has instructions to appear on behalf of the opposite party. Stop. He seeks adjournment to seek instructions and file a reply if so required.
Well,
stop. List this matter on 2 weeks.
Lordship.
Item 12.
Item number 12, I filed the reply today.
What is it?
I've only given a copy.
Are you objecting?
Yes, my lord. My lord, we have taken two contention, my lord. I've given a copy, my lord. Number one, there's a full and final settlement between the parties where they have signed. And we contend that subsequent to the agreement that they're saying, the parties have agreed wherein there is no arbitration clause, madam. That's what our contention is.
There is no arbitration clause.
No, madam, not in the first agreement. They are relying on the first agreement. Pursuant to that, we have taken a stand that pursuant to that, the parties have sat down, settled the matter, and there, in that particular subsequent understanding, which has been put down in writing, there is no arbitration clause, madam. That's our contention.
That will be governed by the first agreement.
Well, that's we have taken one. Let them take.
File your affidavit, we'll see in the registry.
Madam, fine.
Do you intend to file any reply?
I'll see that. By next date, I'll file.
Learned counsel appearing on behalf of the opposite party states that he is going to file a reply to the application for appointment of arbitrator. A copy of this said reply has already been served upon learned counsel for the petitioner. And so please this matter next week.
Grateful. Item 13.
Item 13 on behalf of J.K. Mahapatra request for a pass over, Your Lordship. He's on his legs.
As requested. Yes.
I'm for the opposite party. My Lord, Senior is on his legs. He has intimidated me. Lordship, may take up this matter next week.
Next week, as requested. Yes.
Item 14.
May I please, Your Lordship? May I please, Your Lordship? I am on BC on behalf of the petitioner.
Yes.
Yes, please. That there is an arbitration clause that the dispute shall be settled between the parties through the arbitration clause. So they have filed the counter affidavit and we have already filed the rejoinder. And particularly, there is a dispute between escalation clause between in tender acceptance of tender clause, Your Lordship. The opposite parties is not neither appointing any arbitrator or so that the petitioner comes to your honorable court for the appointment of arbitrator, Your Lordship.
Yes. I am appearing for the opposite party, man. In fact, the petitioner had earlier approved, Your Lordship, by filing ARBP number 10 of 2023, which was withdrawn under Annex 12 at page 95. And that petitioner was dismissed or withdrawn with liberty to refile if a fresh cause of action arises. This order was passed on 21/7/23. After 21/7/23, no further cause of action arises. Therefore, this petition is not maintainable. This is the first submission. The second submission is, my lord, under annexure D/2 at page 96 of my counter, the lordship will find.
Now, where is the order of this court?
At page 95, annex of the arbitration petition, annex 12.
Yes, what is your answer?
Your Lordship, after the withdrawal of the ARBP 10, we approached the honorable conciliator that the matter, if the neutral conciliator will be appointed, then we will participate we will continue the proceeding. But they have appointed their own arbitration again. So we again issued the notice for appointment of arbitrator with objection that your official will be not appointed as a neutral conciliator in this case because he has interest over this matter. They have not appointed a neutral conciliator. And the conciliator is not mandatory in this case. In arbitration clause, there is an arbitration clause and conciliation clause. Conciliation proceeding is not mandatory, Your Lordship.
This is the first cause of action. Your refusal to There is 9/8/2020.
They have already
Interest
refused your
for
lordship.
action.
And my second submission is, my lord, annexure D/2 at page 96 of the counter, which would show that they have received the entire payments under the contract.
That you can, the arbitrator will decide.
No, in fact, that was entire dues was given, and he gave a non-due certificate, and therefore thereafter filed an application for release of the security deposit. The security amount has been deposited, has been released in his favor, which you also will find at page 96. So therefore, my submission is that therefore there is no life claim for.
May I please, your lordship? There is a dispute, your lordship. They have not paid the escalation bill. 1 month escalation, enter 1 month escalation bill.
But
They have not paid.
why did you give that certificate?
Your lordship, in duress, they have forced in duress to issue certificate, sir. Lordship.
They have filed a rejoinder. There is no denial to this non-due certificate.
There is a dispute, your lordship. They have recommended the escalation bill. They have recommended the escalation bill, your lordship.
Where is that no due certificate?
That page 96 annexure D/2, my lord. Of the counter affidavit.
Yes, we are pointing. This application has been filed for appointment of an arbitrator under Section 11 of the Arbitration Conciliation Act. So, next. An objection has been filed on behalf of the opposite party for resisting this application on two grounds. Firstly, a reference has been made to an order of this court dated which annexure?
That is dated 21/7/23 under annexure 12 at page 95 of
dated 21/7/2023, passed in
Please, your lordship.
ARBP number 10 of 2023, whereby the petitioner was permitted to withdraw his application for appointment of arbitrator earlier, with a liberty to file fresh petition if a cause of action arose. Full stop. Secondly, it is the petitioner's, it is the respondent case of the opposite party that the petitioner had given, that the petitioner has been paid entire amount as per his entitlement, and the security deposit too has been refunded. First off, learned counsel appearing on behalf of the petitioner has submitted that since the petitioner has accepted entire amount,
may I please, your lordship,
after full and final settlement, no dispute arise,
Yes.
no dispute survives, and therefore there is no need for appointment of an arbitrator. Next. Learned counsel appearing on behalf of the petitioner has submitted that indisputably an arbitration agreement exists First off, subsequent to this court's order dated so and so, the petitioner had made an application to the where is that letter after the order?
May I please, Your Lordship?
Letter dated 31/7/2023, seeking appointment of an arbitrator. Stop. As the opposite party, through communication dated 9/8/2023, declined to appoint an arbitrator, he has filed the present application seeking appointment of an arbitrator. Stop. Next. Since there exists an arbitration agreement and the opposite party has declined to appoint an arbitrator, arbitrator, this application is allowed, the arbitrator, upon notice issued by the petitioner, a case is made out for appointment of an arbitrator. Who should be nominated?
Any senior advocate for
I would suggest Justice Dr. Justice Ekerath or Justice Biswajit Mahant.
Biswajit Mahant, any justice written, maybe Ekerath or maybe Biswajit Mahant.
Yes.
Item 15.
Your Lordship, item 15, I'm appearing on behalf of opposite party. I'm showing my appearance for the opposite party, requesting for a 2 weeks time. Requesting for a 2 weeks time for giving the objection.
That's it. Weeks. Mr. Swanso appears on behalf of Swanso by way of Wakalatnama. He seeks adjournment to file reply. List this matter on 2 weeks.
Item 16.
May it please this honorable court. The last date, my lords, had fixed the matter for filing of counter by my
Yes, I am filing this. I am filing counter today.
File it in the registry.
Yes, Miller.
Do you have any objection?
Yes, Miller. Yes, Miller.
All right. And counsel for the opposite party states that he is going to file a counter affidavit in course of the day. Stop. A copy of this said counter affidavit has been served upon learned counsel for the petitioner. Stop. List this matter on 2 weeks. My lords. 2 weeks.
Item 17.
Milords, on behalf of Mr. Party, Milord, opposite party. We have filed the counter. Under the impression that I'm going to file the counter. He says that.
What is
let it come next week.
Why? What is the dispute?
Pardon?
Dispute? What is the dispute regarding appointment of an arbitrator?
Pick up that on the ground of limitation, to file the counter.
Limitation?
Limitation. 18 to 24, 6 years last. That is the file the counter. She may kindly take up this matter next week. The party will argue because he is the panel lawyer. The corporation matter. The corporation matter.
Plus, the dispute here is that because of we are basically a company which was supplying medicinal and pharmaceutical items to the other side. They are a semi-government organization.
No, there is an arbitration agreement.
Plus, there is an arbitration agreement.
Then?
their claim is that since the cause of action, the substantive cause of action accrued somewhere in 2018, and now 6 years have passed, and hence this application should be dismissed is what is their stand. I'm trying to explain how during that period, I was before this Honorable High Court seeking this similar reliefs towards which was challenging the order which blacklisted us and the financial implications thereof. So that
All right, he
application
wants adjournment.
Mullahs.
As requested on behalf of the opposite party, list this matter on 1 week.
Item 18.
Obliged.
My lord, on behalf of Sibanan, we shall kindly be adjourned and may be posted after 2 weeks.
2 weeks.
Yes.
As requested, 2 weeks. Yes.
Item 19.
That's item 19. I am an VC loss. I am required to file a rejoinder. So kindly 2 weeks time may be granted. If it's not.
Well, on what ground appointment is being resisted?
They say that since 29, we have not sought for extension of the arbitration agreement of the arbitration proceeding. So now we are barred from taking this ground. Because this is a continuing arbitration proceeding where the arbitrator now, the presiding arbiters, retired Supreme Court judge, as well as Justice P.C. Mishra, who was our arbitrator, is no more there. They have passed away. So I have filed an application for appointment of a fresh arbitrator.
So you will have to go before the district judge.
I will satisfy it's maintainable here. I will satisfy, my lords.
So
Justice Indra Banerjee's judgment, I will satisfy. Just 2 weeks. I will.
Yes. But we have also in some of the cases.
I came across Justice Indra Banerjee's judgment where it says where the arbitrator is incompetent or has died, then this court, that same court of under 11.6 has the power to appoint an arbitrator. I will show that judgment, my lord. Right now I don't have. I will satisfy, your lordship.
You can satisfy today itself.
I don't have that judgment right now with me, brothers. I was actually I was preparing the rejoinder. So,
it's a question of law.
It's a question of like, right now I don't have that judgment, my lord. Your lordship can decide call next week also. Next week also, my lord.
As requested on behalf of the petitioner, list this matter on next week so as to enable him to address the question of maintainability of this application.
Item 20.
I have appeared for the opposite party in the last week. I pray for 2 weeks time for my reply.
2 weeks time is allowed for the opposite party to file. Do you have any objection to appointment?
Is very limited.
All right.
Trademark disputes has been raised. So how far that is arbitrable that he is alleging I have
Everything shall be decided by the arbitrator. How?
I have violated his trademark rights. So if there is a right in REM and specialized courts are there, how far it is arbitrable? That
Even that question can be addressed by the arbitrator.
there are some
All right.
person can be at this.
Yes.
Item 21.
21 minutes. I have not received any instructions yet. If your lordship may kindly grant me 10 days time.
It's for the petitioner.
No.
Then in this time is allowed for the list this matter on 2 weeks so as to enable an ASC to seek instructions and file reply if so required. Yes.
Item 22.
22, your lordships, we have received notice and appeal that we propose that retired district judge Bhaskar Chandra Shah, if he agrees.
Maybe appointed as arbiter.
Is he there on the panel?
Yes, yes.
Oh, that's good. Yes.
Item 23.
We had filed an application for appointment of arbitrator and they have filed a counter, only disputing our claims.
To counter, you are disputing the claim. So we are.
And it will be taken up next case, not
Why?
party will argue the matter, having some personal difficulty today. Today, if the party is having some personal difficulty, will argue the matter. Only 2 days time.
Next week has requested on behalf of the opposite party.
Item 24.
Oblige.
But I'm appearing for the opposite party. Lordship was pleased to grant me time to obtain instructions. Instructions have come. I was suggesting to my learned senior and subject to your lordship's kind consideration. The matter be referred once to mediation. We'll try and sort it out because my instructions were that the bills have been cleared of this contractor. His claim is limited to
Yes, and madam, so we tried our level best. They are in the office.
That course is not open.
Not open. Then Miller, your lordship would be pleased to appoint an arbitrator. Miller. I was suggesting Honorable Justice Mr. Biswajit Mahanti retired.
From my side, my Justice Honorable Justice Biswanath Ratha is there also. My lords be pleased to consider any of them.
Sole arbitrator.
Solar.
Yes, Mr. Mohanty.
Justice Biswajit, ma'am.
Item 25.
Time for the opposite parties, my lords. Out of the claim amount of 60 lakhs, some odds, my lords, 38 lakhs have already been paid. We are in the settlement procedure, my lords. My learned senior will agree with that. Some amount are yet to be paid. It will be paid within some time, lords. Just in short adjournment will suffice. We'll pay the rest of them.
Council representing the opposite party submits that the parties are in the process of settlement and question of appointment of an arbitrator may not arise if the matter is adjourned for 2 weeks.
Yes, sir. A week later, my lords.
3 weeks. Post of discuss matter on 3 weeks as jointly requested.
Item 26.
My lord. I'm for the opposite party. I have instruction also and.
And what is the
My
instruction?
lord, page 22, clause 1.3. My lord, there is no scope for appointment of arbitrator. 1.3. Page 22. The last paragraph.
Page 23.
22 of the application, arbitration petition. The last paragraph.
Yes.
Lord, any dispute, controversy, or claim arising out of or relating to this contract or the breach, termination, or invalidity thereof shall be decided by the Chief General Manager, PNC, Odisha Industrial Infrastructure Development, Bhubaneswar. In case of the consultant's disagreement, he can represent his grievance to the Managing Director, IDCO. The decision of
There is
Managing
no
Director.
representation on behalf of the petitioner. And counsel representing the opposite party has submitted with reference to clause 1.3 of the general conditions of contract that there is general condition of contract.
My lord, it's part of the agreement.
Element of
General
the
conditions of contract.
general condition of contract that there is no stipulation for resolution of dispute through the process of arbitration. So I'm prima facie satisfied with the said submission advanced on behalf of the opposite party. Stop. There is no representation. Since there is no representation on behalf of the petitioner, the matter is adjourned to Wednesday.
Well,
Item 27.
Item 27, if I may please your lordship. The arbitration petition has been admitted on 11/9/2024, your lordship. The requisite has been filed on the next date itself, your lordship, 12/9/2024.
Who is for the other side?
As of yet, your lordship, no one has appeared.
Hmm?
As of yet, your lordship, no one has appeared.
Notice served.
Yes, sir.
Huh?
Yes.
Despite service of notice, there is no representation on behalf of the opposite party. Stop. List this matter for 2 weeks, awaiting appearance of the opposite party. Opposite parties kar raha. It is made clear that in case the opposite parties do not appear despite valid service of notice, the court shall appoint an arbitrator under section 11(6) of the Arbitration and Conciliation Act. Yes.
28.
8 minutes notice was issued and the requisites were filed.
Service?
Service minutes.
Hmm?
Service is complete. Yes, sir.
Valid services.
Despite service of notice, there is no representation on behalf of the opposite party. What is the dispute? What is the amount?
The amount is 35 lakhs.
Yes.
Item 29.
That's item 29, my lord. Clause 25 as well as the 25(3) provides arbitration clause, my lord. The state has already filed counter, my lord. The claim is, my lord, the subject to my learned friend, my lord. Claim is within 1 crore 67 crore. My lord, I suggest to senior advocate Mr. Manoj Misra or Mr. Ashok Parija or Gautam Mukherjee, any subject to.
But my only objection is that the precondition, the prerequisites of initiating arbitration have not been completed.
What is that?
If your lordship has page 80 of the agreement, just before the disputes clause, just before the arbitration clause, clause 24.1.
Page
80. The agreement starts at page 13. At page 80.
Just a minute. Yes.
Lordship has page clause 24.
Yes.
The penultimate paragraph. If the contractor believes that a decision taken by the engineer was either outside the authority given to the engineer by the contract or that the decision was wrongly taken, the decision shall be referred to the dispute review expert within 14 days of notification of the engineer's decision. Well, it's the petitioner has at annexure 5, page 124, referred the matter to the dispute review expert, but nothing has been brought on record whether this dispute was whether the matter was
No, but where
pursued
is
with
the
the expert.
arbitration clause?
Clause is at 25.2. 25.1 says the dispute review expert shall give a decision in writing within 28 days of receipt of a notification of dispute. The dispute review expert shall be paid daily at the rate specified in the contract data together with reimbursable expenses of the type specified in the contract data, and the cost shall be divided equally between the employer and contractor. Whatever decision is reached by the dispute review expert, either party may give notice to the other side to refer a decision of the dispute review expert to an arbitrator within 28 days of the dispute review expert's written decision. If neither party refers the dispute to arbitration within the next 28 days, the dispute review expert's decision will be final and binding. And then the arbitration shall be conducted in accordance with the arbitration procedures stated in the special conditions of contract.
Page 93.
Yes, sir.
Well, it's my submission is
Yes, sir. So where is the decision of the dispute review expert?
See, your lordship, I kindly have annexure 5, page
No,
1.
let him.
The agreement provides, Miller. First, I have to approach the dispute expert Miller committee as per the Miller. The counter specifically they said that I have unilaterally appointed Miller. Suppose the dispute expert Miller has been notified in the agreement. That is my learning has not shown your lordships. That is your lordship contract data, page 70 Miller, page 97 your lordships.
Yes.
Lordship can have seen. The this is both part. The agreement provides a named dispute expert, and he has to take a decision within 28 days, Milord.
No, that is not named. What is named?
Milord, name is R.K. Das, page 97, Milord.
What are you submitting? That the agreement provides a named?
Milord, my first submission, your lordship, the dispute review expert shall give a decision in writing within 28 days from the receipt of a notification of a dispute, Milord. Here, the dispute review expert, who is to be dispute review expert, has been defined in the contract, that is page 97. That is Mr. R.K. Das, the former engineering chief secretary of the works department. I, Milord, request the 18th June 2023 to the dispute expert committee, Milord. That is annexure 5, page 124, Milord. Milord, thereafter, Milord, till Milord, even he has to take a decision 28 days, Milord. Even up to 30th April 2024, he has not taken any decision. So I invoke the Milord, if they fail to Milord appoint any decision within 28 days, I Milord invoke arbitration notice on 30th April 2024, Milord. That is page 127. And they replied the department that because of that is also the authority also replied that my appointment to arbitrator. They say that because of no claim certificate issued by page 133, so your price escalation cannot be considered. My request for appointment was denied, page 130, Milord. Your lordship, kindly see the refusal of appointment of arbitrator, page annexure 7, page 130. Milord. Lordship, page 130, your lordship. This is the reply of the employer. Appointment of sole arbitrator as per clause 25(3) of the agreement, release of security amount, your lordship. The operative para, Milord, page 131 I am placing. Further, it is to mention that you have claimed material escalation 12,19,400, POL, petrol oil lubricant, escalation of rupees 3,70,000 and labor escalation of 18 lakhs. However, you have also furnished no claim certificate along with the EOT application in shape of notary affidavit and stated that you will not claim any compensation including price escalation from the department during the extension period. So it is presumed that no financial dues of the above cited were ending with this division. Hence,
you're requested to verify the above payment and at your level, and the payment confirmation is later issued from the regional office Bhubaneswar is enclosed here for ready reference. This knowledge of payment may be furnished, undersigned, and early date for your information and necessary action. So, the mechanism under the agreement, the name arbitrator, he has not taken any decision within 1 year, my lord. The alternative intention of the agreement provides that if it is not settled, then it will go to the arbitration, my lord. And there is a valid arbitration clause, that is clause 25(3)(a), my lord. Special condition, your lordship, page 93, your lordship. And the
Page?
Page, your lordships, 93, your lordships. Lordship, 25 arbitration GCC last paragraph. Arbitration general condition clause 25(3). The procedure for arbitration will be as follows. In case of dispute or difference arising between the employer and a domestic contractor relating to any matter arising out or connected with this agreement, such dispute or difference shall be settled in accordance with the Arbitration and Conciliation Act 1996. The parties shall make effort to agree on a sole arbitrator. And only if such an attempt does not succeed, and the arbitral tribunal consisting of 3 arbitrators, one is to be appointed by the employer and the contractor, and third arbitrator to be chosen by the 2 arbitrators so appointed by the parties to act as a presiding arbitrator shall be considered. In case of failure of the 2 arbitrators appointed by the parties to reach a consensus within a period of 30 days from the appointment of the arbitrator, subsequently the presiding arbitrator shall be appointed by the Council India Road Congress. So there is a since the claim is within 1 crore, and I have availed the dispute redressal expert under clause 25(3) named dispute. He did not take any decision, my lord. Then, my lord, April, my lord, 2004, my lord, 2030, April 2024, I noticed for appointment of arbitrator. They replied, you have a signed a discharge certificate, my lord. So this discharge certificate, this is the main object of the counter affidavit, my lord.
You are frustrating the arbitration clause.
Well, the short point is.
No, the short point is that why that the expert did not decide.
I'll straight away come to that. If your lordship may kindly have annexure 5, page 124. This is the purported reference to the review expert. My lord, there is a postal receipt, but there is no proof whether this notification has actually been served on the expert. That is number 1. Number 2, the agreement envisages that fees will be paid to the expert. There is no proof whether any fees have been paid by the petitioner to the expert. Therefore,
have you taken all these points in your reply?
Yeah.
Is when there is a only setting is held, then it will be fees will be paid. Then if there is any setting will be held, this postal receipt acknowledges all parties, not that only dispute, my lord, 126. Chief engineer, executive engineer, I acknowledge postal receipt to all, communicate all. And the fees, deposit of fees will arise if there is any setting, my lord. There is no setting, my lord, up to, my lord, within 1 year.
There is no proof that annexure 5 has been served on Mr. Arkidas.
This counter paragraph 7 is said that you are unilateral. My lordship, kindly have paragraph 7 of the counter.
No, where is the proof?
Your lordship, page 126, your lordship.
No, whether it was received by him or not.
Your lordship, that specific, your lordship, my humble submission, that postal receipt, annexure, my lord, I annexed postal acknowledgement, my lord, postal receipt, acknowledgement, I will produce, your lordship. But this stand has not been only paragraph 7 of the counter affidavit. I will file that acknowledgement whether it is by registered post, paragraph 7, my lord. The paragraph what my learned friends are meeting, paragraph 7 say the counter affidavit, I have unilaterally appointed a expert, your lord.
That I withdraw. That objection I
withdraw. You have filed in affidavit, my lord.
That objection.
Now you are in the time of advancing argument, there is no receipt, my lord. So it is contradictory, my lord.
All right, you say.
Well, I have submitted the postal receipt. I will file proof of the common, my lord, acknowledgement, your lords. to all parties, page 126 postal receipt. My lord. I have original postal receipt with me, my lord. This is my file, my lord.
In terms of the agreement in question, dispute is required to be referred to arbitration if what is it called? What is expert review?
Dispute review expert.
If the or if a party is aggrieved by the decision of the expert review,
dispute
review experts. Full stop. The dispute raised by the petitioner in June 2023, but till date no decision of the expert has been communicated. So next learned counsel appearing on behalf of the state has submitted that there is no evidence to the effect that the petitioner had in fact that the petitioner's request addressed to the dispute review expert was in fact received or not. So next learned counsel appearing on behalf of the petitioner states that he will be filing a supplementary affidavit bringing on record the acknowledgement of the communication of the request made through registered post. Stop. As requested, list this matter on 1 week.
Yes,
Item 30.
Look, item 30, I'm appearing on behalf of the opposite party, my lord. I'm praying 2 weeks time to file my objection, my lord.
2 weeks.
31.
Obliged, Lordship. Yes.
31, my lord, I am appearing today for the opposite party. I seek 2 weeks time to file and reply.
So appears on behalf of the opposite party. Stop. He submits that he shall be filing wakalatnama in the registry. Stop. He further seeks time to file objection to the present application for appointment of arbitrator. Stop as requested. Place this matter on 2 weeks.
Item 32.
One appears. This matter. Next week.
33.
May it please, Lordship said issued notice.
I am appearing for the opposite party. I had filed wakalatnama on 23rd September, even though my name is not reflected. There is no objection to the appointment. Lordship, I suggest Justice Biswajit Mahant.
Biswajit Mahant.
Item now 34.
I'm appearing for the petitioner by law. 34, I am for the opposite parties, milords. We have filed our wakalatnama on the last date. Let's say pray for 4 weeks time for filing objection.
Why 4 weeks? And is there any objection?
Yes, let's 2 weeks time.
2 weeks.
Noting in the cause list says that no counsel has appeared for opposite parties, while we have filed our wakalatnama on 9th October.
Let me move. So we reflected in the cause list as also on the brief. Yes.
35.
My lords, I beg to appear for the petitioner. My lords was pleased to issue notice, and my lords, the additional standing counsel, Mr. Arnab Behra, had accepted notice on the last date of hearing.
My lords, I have not. Today, on the last occasion, I did not have a copy of the brief. My lords, I have received a copy of the brief. Your lordship may grant me 2 weeks' time to obtain it.
No, my lords, in this, he has not sought liberty to file any objections. So there is no need for any time.
All right, 2 weeks' time.
My lords, for instructions, I have my lords had asked me to suggest a name. I had asked my lords that we will leave it up to my lords. If that can be done, we'll save a week, my lords. Otherwise, I can suggest a name, my lords.
No, let him file a reply. If he wants to file, let him file, or let him seek instructions at least. He says he did not have the copy of the application with him. Now that application is there with him, let him seek instructions at least. This is the minimum which.
That is right, my lords. The limited scope of objections that can be taken in 11 minutes.
2 weeks.
My lords, may kindly give us a short date, my lord?
2 weeks, Mr. Counsel.
Obliged, my lord.
Yes.
Specialist item number 1, BLAPL 9763 of 2024.
I beg your pardon, my lord. On behalf of Mr. S.K. Dwivedi, I am seeking an adjournment next week, my lord. He is on his selection. So, pardon, madam.
It's listed for the first time. Because 34 kilos of ganja. So I will obtain case diary of nothing. Grant me 2 weeks time.
Yes.
Item 2, my lord. My lord, case diary may be called for in
Item
this.
2.
Case diary may be called for in this matter, my lord.
Why?
My lord.
Why? You have filed an application for bail.
Yes, my lord. But the
And you
case
want
diary
me to
has.
call for the case diary.
Yes, my lord. The case diary has not been called for yet, my lord. So requesting for the. Yes.
It is not that in all the cases I am required to call for the case diary.
Oh. But I'm actually appearing on behalf of the counsel for
It is
the.
a different matter.
Maybe adjourned short date, my.
Let me see. This is anticipatory or regular? Regular bail.
Regular bail.
Regular bail.
307, 326.
What is the FIR?
My lord, I'm just appearing on behalf of the petitioner, my lord, but
All right,
I'm not
all right.
having.
What is the FIR?
FIR is that lots of page.
What is the allegation?
Allegation, lots of serious allegations are there. They've been assaulted on the head and people are sick. Was taking meal at that time. The accused persons came there and assaulted him by means of bhujali and koturi. As a result of his sustained bleeding on his head, chin, backside of the neck, arm, eyebrows, and chest. That's why 307 as well as 326 is there because hospitalization for 20 days.
Is she a female? The petitioner is a female.
No, Milos. He. Saurabh Das alias Montu Das.
Male, man.
And what is the nature of injury?
Yes, sir. Injury report, sir, they have not given. No injury report had you submitted with the, along with the bail
Grievous.
application. Only, I'm sorry, extremely sorry. There is one grievous injury on the forehead. Fracture of, yes, on the forehead, there is a fracture, it's grievous in nature. Then on the mandible at the chin, there is also fracture, which is serious in nature. I mean, grievous in nature. And the third injury on the back.
No. Case diary with injury report. Yes.
Item 3.
May I please, Your Lordship?
Yes.
My Lord, this is the second successive bail application before Your Lordship. Kindly have a glance over the order passed in the bail appeal 2570 of 24. That is on record, my Lord. In that order, Your Lordship.
Which annexure?
No, not annex, sir. The earlier bail application.
How can
That
I?
Yeah, unless if file sheet not circulated.
How can I see that?
My Lord, as per noting that, then, my Lord, it may be called along with that, with this bail application. BL appeal 2570 of 24.
So when was your application rejected?
My Lord?
When was the order passed, earlier order passed?
27/3/2024.
Both, both 2 and 3 arise out of the same FIR. But both 2 and 3 arise out of the same FIR. There are two accused persons, two different bail applications. In the item 2, also have the directive to obtain the injury report, other things. So you also may take it up this also along with that, so that I can obtain it.
So there is no progress at the trial.
No, my Lord, there is no progress in the trial.
But
Trial has not commenced, my Lord, yet.
my friend in the certificate has given that there is no previous.
No, my Lord, that is due to mistake of the.
Say that you have not disclosed the previous bail application.
No, but after expiry of 6 months, as per the direction of my Lord, I have filed the successive bail application, my Lord. That was on 27/3/2004, and this was filed on 27/9/2004. So, in obedience to Your Lordship's direction, this successive bail application has been filed, my Lord.
Petitioner's prayer for. The petitioner had earlier approached this court for grant of regular bail in connection with GR case number 24 of 2024 arising out of Bandar Munda.
Banda Munda Millers, BUNDA.
Bandar Munda PS case number 5 of 2004 or 24, which was dismissed by an order dated, which was withdrawn by, which was permitted to be withdrawn by an order dated 27/3/2024 with a liberty to renew the prayer for bail after 6 months if in the meanwhile there is no progress at the trial. So the petitioner had renewed his prayer for bail by filing the present application on a plea that there has been no progress at the trial. Stop. Next, call for a report from the court of learned. Whose court?
So now it is ST case notes. Commitment has already been made. Lordship may call for report from the
Second additional session judge Raurkela.
Second session Judge Raurkela.
Second additional session.
As regards the stage of the trial. Yes.
Lordship may mention the case number. The ST case number.
ST case number.
106 of 2024.
This is case on 3 weeks.
Orders item 4.
Obligement.
May I please, Your Lordship? Item 4, 5, and 6, both arising out of same case. But the case were 3 persons, 2 ladies and another person. But we were traveling in a passenger bus, and police recovered 4 bags from the slipper of one of the accused, namely, my lord, who is
No, so Lordship, sir, please to direct me to obtain the case diary and other things. Abide order dated 25/9.
Yes.
I've obtained the case diary and other things. I could not go through because of my health. So only next Wednesday, Lordship may call it so that I can.
Next week, just allow him to go through the case diary. As requested by DGA, list this matter on. Next week, list this matter on 1, 2, 3.
Item 4, 5, and 6.
4, 5,
4,
6.
5, and 6.
For hearing item 7.
Yes.
Lordship, in item 7, the conducting counsel is on her legs in another court. The conducting counsel is on her legs in another court. If I may pray for one Passover.
You take the advantage of his absence.
Lordship, I'm not well versed.
All right. No. I can understand that you are not ready.
The Lordship's last occasion has directed me that the Lordship will be given a list of cases up to the year 2005. But they obtained this.
The list has not been given.
Now that is, I think I talked to him. They prepared it, but not yet given. So if I get it, if the petitioners have died, it will abate because 2099, 2000, more than 30 years cases.
Your Lordship, this case is well before 1990. This case has occurred well before 1990, as per my instruction.
Next week. How can you get the information?
I can get from the concerned police because they are the PS is concerned PS case. They are the accused. I can get the details of the nurse.
No, but did you get in fact the matter was adjourned at your instance?
Yes, Your Lordship. Your Lordship, my senior is prepared. She just is in her legs in another court. This matter may kindly be taken up as the last matter, if Your Lordship pleases.
So the petition is alive.
That instruction I have to take.
No.
So that instruction, Your Lordship, we don't have. However, we have prepared the matter. My senior will be appearing in it. She's on her legs in another court.
All right, let us see. इसको भी नहीं करना, otherwise next week कर लोगे.
Item
Yes.
8.
Lordship, item 8, I am appearing for petition number 4. We have filed Wakalat Nama, but it has not been reflected in cause list. Lordship.
Yes. Yes. Next week. दे दो हमको list दे दो. Even the
Lordship,
list. कब का prepare हुआ वो?
Lordship,
Will
Lordship,
come after 2 weeks.
Lordship, my name may be reflected in cause list.
Item number 9.
Yes.
Item 9.
No representation 2 weeks.
Item 10.
Same order. Same.
Item 11.
Lordship, item 11 on behalf of Ambika Prasad Rai, Lordship, kindly taken up next week, Lordship.
Yes, I requested on behalf of the petitioner list this matter on next week.
Item 12.
One appears 2 weeks.
Item 13.
Lordship, item 13, a joint compromise affidavit has been filed, Lordship, in this case, Lordship. Both the informant, who is the opposite party number 2, and we are for the petitioner, Lordship. Petitioner number 1, husband, Lordship. We are appearing on behalf of petitioner number 1, Lordship.
So what will be the effect of that compromise?
Sir, Lordship, marriage was on the year 1988.
What is the effect of that compromise?
They have settled their dispute. They have been settled their dispute.
Whether criminal disputes can be settled.
After conviction, maybe before also.
And even before that, the criminal act cannot be compromised.
Lordship, after registration of the FIR, Lordship, they are again.
Even after registration of FIR, Mr. Counsel, we'll have to appreciate this. That see, if a criminal case is lost,
Lordship,
either that can be compounded,
Lordship, yeah.
or if there is any provision,
Lordship,
or the person shall be acquitted or convicted.
Lordship.
There is the question of third thing, compromise, and that too after. Let me see. What is there?
Certain decisions, Lordship, will go through it.
Who are you?
I am for petitioner number 1. Husband. Lordship.
So what is the allegation?
Allegations against me, Lordship, that during the conjugal life and period, I have tortured my wife and my mother, which she is no more. She was also participated in this alleged occurrence, Lordship. And one day she left and filed the FIR, Lordship. And the allegation about dowry demand and torture and.
Your wife died?
No, she is there. She has filed. She's there. She's in the opposite party number 2, Lordship. My mother died, Lordship.
So what is the conviction?
After the conviction.
Conviction under which section?
498, 323 so far as husband is concerned.
That's it.
And so far as I think Sanjulata Mahapatra may be the
mother of the present petitioner.
498, 379.
379, Lordship. And 4 TP Act, Lordship.
379.
379 against the mother.
Against the mother who died.
Who died. As per my instructions, she has died, Lordship.
So who is alive?
Lordship.
Only you. How many petitioners are there?
Lordship.
2.
There were 2 petitioners initially, and in the meantime, petitioner number 2, who is the mother of the petitioner number 1, she has died, Lordship.
Yeah. Yes, I am allowing this.
You similarly mentioned that so far petition of two revision abates, so far one is concerned.
The petitioners have put to challenge the present criminal revision application, comma, an order, comma, where is the appellate order?
Order,
They
Lordship,
have not mentioned.
Appellate order.
Order, Lordship, order dated 15/3/2001.
Passed by so and so.
Additional decision for the Housing.
Whereby the Ullithana School and Trial Court, then appellate court has affirmed the finding of conviction recorded by the trial court. No, this is, sorry, this is not against the appellate, this is against the order of the trial court.
No, Lordship.
No, revision is against the trial court convicted. Thereafter, the appellate court learned additional sessions have confirmed the appeal there, because now they filed the revision.
No, where is the order?
No, it's there, no, set page. Of course, they have not numbered it, but the appellate order is there, no. If you switch look at after the your petition, immediately after the affidavit,
Eight page
number
number
eight.
eight, Lordship. But it has not mentioned.
Yeah, this is
The
appeal
petitioners have
arises.
put to challenge a judgment and order. But why this, it says Sessions Trial 488?
Because it was tried by the learned CGM.
CGM.
Assistant Sessions Judge.
Assistant Session.
Appeal assistant session judge, but the initial case was tried by the learned CGM.
CGM.
CGM order ta nahi?
ଅଛି ନା? ଅଛି। ଏଇଟା ହିଁ order ଟା।
ନାଇଁ। Offense not there. Because 307 was there initially during in the trial court. That is why it was tried by the learned CGM.
So therefore, we am putting this question that why this is ST number. ST means Sessions
Sessions
Trial.
trial. 307 is a sessions trial case.
307 was trial of 307 also.
Initially was 307.
Tell you. An order passed by the learned additional district and session judge Jagat Singhpur dated 15/3/2001, whereby the learned court has upheld the conviction of these petitioners for the offense punishable under sections 498A, 323 of the Indian Penal Code and section 4 of the Dowry Prohibition Act. Stop. Whereby appellant number 1 kar dena. Appellant number 2 was convicted of the offense punishable under section 498A, 379 of the IPC and section 4 of the Dowry Prohibition Act. Stop. Next. petitioner number 1 is the husband of the informant, lordship, of the informant. So petitioner number 2, comma, the mother-in-law of the informant is said to have died during the pendency of the present criminal revision application. As per the instructions which learned counsel for the petitioner has received. Stop. The revision application, to the extent it relates to petitioner number 2, abates. Stop. Next. Learned counsel appearing on behalf of the petitioner has submitted, petitioner number 1 has submitted that it was primarily because of the matrimonial discord between him and the informant that the criminal case was instituted. Stop. In course of time, the two resolve their disputes and are living together. Stop. They have children out of the said wedlock. Stop. A compromise petition has been filed. Compromise affidavit has been filed on behalf of petitioner number 1, stating that the parties have resolved their disputes. Stop. Learned counsel for the petitioner has submitted that no tangible purpose shall be served in view of subsequent development by upholding the conviction for the offense punishable under section 498A of the IPC and section 498A and 323 of the IPC, particularly as the conviction under section 4 of the DPA Dowry Prohibition Act that is compoundable.
Yeah, difficult.
Is compoundable, and the parties have arrived at a compromise. So stop. Next, in view of the subsequent development and the compromise affidavit filed on behalf of the petitioner number 1, this revision application, the conviction recorded by the order passed by the appellate court upholding the conviction for the offense punishable under section 498A, 324-23 of the IPC and section 4 of the DP Act is set aside. The petitioner number 1 stands acquitted of the charge of the offense punishable under section 5.
It's a joint compromise affidavit filed.
Joint. The petition number 1 stands discharged of the liabilities of bail bond. Yes.
Item 14.
Yes, my please, your lordship.
Yes.
My lord, I'm with due apologies, my lord. The conducting counsel of this present matter, Mr. Mahapatra, is no more. And the case is also of a very old matter, and I could not trace the file, unfortunately. So, and I also do not have the instruction regarding the position of the petitioner. So, I may be granted some time to see the instruction and get.
Is this case 2 weeks? So as to enable written counsel for the petitioner to seek instructions as regards whereabouts of the petitioner. There is only one petitioner.
My lord.
Item
Yes.
15.
Obliged.
Please, my lord. That's on behalf of Mr. Panda, I may be permitted. That's here, the revision arises out of an appeal from the learned session judge Kunjar, wherein I have been convicted under section 409 of the Indian Penal Code for a period of 5 years, rigorous imprisonment, and 3 years for often
409?
409 IPC.
409?
468 and 473.
Yes, what is the sentence?
Look, the sentence is for a period of 5 years for 409.
468?
And 3 years for 468 and another 3 years for 473. Substantive sentence being for 5 years.
So what is the allegation as
Well,
regards 409?
Well, the allegation is that I was posted as the branch postmaster in the office from 14 to 1992 to 13/6/1999, whereupon being involved in a murder case, I was put into custody. And during that period, the postal subdivisional inspector of Ghotaga was directed by his higher authority to take charge of my post office, wherein on taking charge, he took the key and the cash from my wife, that is apparent from the investigation. Those periods, some depositors came for withdrawal of money from their savings bank passbook. And it was subsequently found that the informant verified the savings bank passbook of the depositors and found that petitioner has misappropriated a sum of rupees 6,430 by forging postal documents and cheating the depositors. That is the allegation.
And what is the proof?
Well, the proof, the basis on which the conviction has been sustained is on the fact that the informant has come to the conclusion on the basis of some evidentiary records available which have not been taken into account, as the depositors in the case who have been examined, they have not stated in their evidence as to on which day they have given the deposit and to whom they have specifically deposited. And I was in charge of the post office for a particular period wherein this informant who has taken over charge has subsequently found out that there has been misappropriation. So far as to attract the 409, the ingredients, there is nothing as such, because I'm not a banker, merchant, nor an agent. I'm not.
409 will apply, Mr. Counsel.
With due respect, there is a judgment of the Constitution Bench of the Supreme Court.
What does it say?
It is 62 Supreme Court 1764.
What does it say?
There, my lords, their lordships say that the relationship between banker and customer is not one of trustee and beneficiary. So since the relationship between banker and customer is not one of trustee and beneficiary, the question of entrustment doesn't arise, and therefore criminal misappropriation will not. That was a case, my lords, which related to
So therefore, that will not lie within the meaning of section 405, according to you.
Yes, that is what the Constitution Bench says, my lords. I just came across that yesterday, and I didn't have time actually to go through the whole judgment. But that is the import of what the judgment says.
So,
yes, for the last 40 years, I am used to, my lords, 409 being applicable to these cases.
all right, as requested on behalf of the petitioner, this matter on next Wednesday.
Yeah.
Item 16.
What is that judgment? Give the citation.
Yes, that is 62 Supreme Court, page 1764.
AIR. AIR, I think. No, I have not.
1764.
176.
Item number 16.
May it please your lordship. My lord, the occurrence is 30 years before 93. My lord, conviction is 324 and 326. Sentence is 6 months and also under 326, 2 years. My lord, it is out of a family fight, free fight, may I submit. My lord, the uncle called to these appellants are the nephews, called to nephews, appellants, and asked them why they have misbehaved the niece, the daughter of another brother, 3 brothers perhaps. These appellant belong to sons of one brother, complainant is one uncle, and so this was the case and counter case is there. And both sides have suffered from injuries. I mean, our case was not investigated, it was later registered out of the same incident, and the allegation that some acid-borne injuries are there. When we were called, my lord, our case is that we were assaulted first. And we have given evidence, my lord. And your lordship knows the defense plea, if it is probable, may be taken into consideration because it will be decided on the basis of the preponderance of probability and not like prosecution to beyond a reasonable doubt, my lord. Prosecution is required to prove beyond a reasonable doubt, your lordship knows, but the defense evidence is to be considered on the preponderance of probability. If the defense is probable, it is to be taken into consideration.
So what is the rationale behind that principle? What is the rationale behind the principle which you are stating?
That if your lordship would ask me, my lord, I would make some search and give some, but that was the, because I heard from my senior's mouth.
No, you should not.
That is that I am submitted 40 years before, my lord. That is. So it was the exact version. The defense plea probable cannot be accepted. So then, my lord, there is no seizure of any acid bottle, throwing of acid, nothing. My lord, seizure witness 1 and 2, they have not whispered anything regarding seizure. Suddenly, my lord, is the prosecution case that the acid was poured and they have, no doubt they have suffered some injury. We have also suffered, but not that we are the author of the crime, my lord. And the very genesis of the prosecution case, prosecution has suppressed. It is because of the fact when we were called, allegations were made against us that why we have misbehaved the niece, my lord. It seems to be more probable that we have been assaulted first, my lord, during the course of the occurrence, my lord. 2 affairs were lost, my lord. 1 affair we are facing the trial and we have been convicted.
So your conviction is for the offense under section
324, 6 months and 326, 2 years, my lord. 30 years before the occurrence for my lord's consideration.
date of occurrence?
Huh?
Date of occurrence.
Date of occurrence is 1/8/93. 1st August 93.
Date of conviction?
Date of conviction is 2/11/98 by the trial court.
And appeal?
Appellate court 4/6/2001.
And when were you granted bail?
Bail regarding custody period, I cannot submit, but we are granted here appeal. We have been granted bail immediately after the case was filed. Must be in the 2001. Appeal is revision is of the year 2001, and after filing of the revision, here bail was granted. But there the position must have been granted, but maybe some period inside custody, I don't mind. I had sent information I could not get, but appeal 2001, my lord, the criminal revision was pressed and bail bail.
You must have been released by the appellate court also.
Yes.
because it is 2 years.
And the trial court also.
Yes, but after arrest or some days or something, it is sometimes probable, my lord. Some days conviction, sorry, arrest, custody. But trial court, appellate court, bail has been granted, my lord. Must have been. 2 years, your lordship knows 389, 2 years is granted. But what is the case of the prosecution, genesis, my lord? That has been suppressed by the prosecution. I was called by the uncle. It's a family, all are family related. And I was asked why I have misbehaved, daughter of another brother, niece. And some assault was made. We lost the affair. They have lost also affair. No indicating that it is a born injury. My lord, no acid bottle, nothing has been seized. PW1
No
and
acid.
my lord.
Acid bottle.
Yes, yeah. No bottle has been, but we have been held liable. But there is no seizure. 1 and 2, PW1 and 2 is not saying if acid bottle, nothing has been seized, my lord. Simply saying that born injury there and we are the author of the crime, my lord, in the family, my lord. Your lordship may kindly appreciate this position. I had intimated there. By now, I have not got anything, but I thought since 1 or 2 adjournment is there, it is desirable on my part to address your lordship. And PW5 says regarding a counter case, the trial court did not accept it and consider it as a counter case. PW5 statement is also there. Regarding if any custody period is there, if the state, if your lordship would kindly appreciate if they take instruction also that.
LCR କହିବେ ନା ଆମେ କେମିତି କହିବା
LCR ନା
ଏଠି ତ ଆପଣଙ୍କ ମୋ ପାଖରେ ଜଜମେଣ୍ଟ କପି ନାହିଁ ଖାଲି ରିଭିଜନ
ସେ ତ ଠିକ ଅଛି ମୋର ବି my order sheet is torn also.
Provision of offenders act, no? Yes, Mr.
But all these things, my lord, because I don't have, accepting the petition, I don't have the judgments, both the courts below. One my points raised by my senior are all not questions of fact. It's a revision. But if you also can examine actions of PO Act, then you'll also consider that. Otherwise,
PO.
yes, Professional Offenders Act, because consider the
PO
age.
is very difficult. Just see. In fact, I was seeing that.
Okay, sorry.
Just examine section 3 and 4.
Yeah.
Section 3 will not cover his case. Section 4, there is a procedure prescribed.
One thing, the PW5 had given the FIR, that is suppressed. PW9's FIR has been proved and inquiry into. Both belong to the prosecution party. The PW5 has been examined, says, I submitted a written report to the Jamadar. That is not inquiry, that is suppressed. That's why I submitted with the leave of the Honorable Court that the prosecution has suppressed the very genesis root of the case. That the uncle asked, nephew went, and nephew said that I was assaulted. FIR was lodged. That is the counter case that has not been inquired into. Thereafter, my lord, alleging that burn injuries are there. There is no seizure in view of the mouth of the PW1 and 2. That is for my lord's consideration. 93 occurrence, family.
No, if 4 is to be applied, then he has to be under the scrutiny of that district welfare
Then you will have to have report.
Yeah.
Section 3
Of
will
good
not
conduct,
apply.
right.
All right, I'll see.
Yeah.
Oh, bless.
Next week. That's good. With all the file.
Item 17. Item 17.
What is the conviction in this case? No one appears next week.
So,
Huh? Let us reminder we sent to the Superintendent of Police Cuttack in the light of this court's order dated 18/9/2024. Passed in this case. Yes. 2 weeks. Why these? There was an order the Superintendent of Police should have submitted in the
because unfortunately I don't have the file. I've missing
Yes.
from office. I'll try to get it.
Yes. Next.
Item 18.
Hey, Legal Lordship. My lord, today I am suffering from some throat infection and viral fever, my lord. So I pray, my lord, can it be taken up next week? Because this matter has been compromised. 324 he has acquitted, but 307 he has.
What is the offense?
But 307 have been convicted. 94
307
offense.
cannot be compromised. What is the conviction?
My lord, there is a conviction of 307 and sentence of 7 years. Occurrence has taken place in 94. That the petitioner has undergone 1 year.
That
1
cannot
year.
be compromised.
Yes, my lord. My lord, there are judgments, my lord. Your lordship, allow me.
There is a judgment that 307 can be compromised.
Yes, my lord. There are two Supreme Court judgments and
But
recent
307 can be compromised.
Yes, my lord. Yes. That is 90. That is reference is 2014 6 SCC 466. Another 2014 9 SCC 653.
Have to see.
Yes, ma'am. And my lord, even another taking another view that he has undergone 1 year, and even if your lordship may not accuse him, but the period can be set up also. There are also judgments.
There are also judgment of what?
Judgment that the period can be set up, period of sentence, because taking into account the occurrence has taken place in 1994 February. He has undergone 1 year sentence. He may not be acquitted, but it can be set up.
As requested on behalf of the petitioner, this is matter on. Next week.
I'll come physically, my lord, because today I have some personal commitment. The compromise petition was filed in the trial appellate court, and so also here the affidavits have been filed.
Item 19. Item number 19.
May I please, madam. The petitioner and petition number 1 and 2 are convicted under section 363 and 366, and 364, 363 it is for 3 years, and 366 it is for 4 years. In default to pay fine of 500, in default to go 1 year. Cases like that, the victim girl who was abducted, my lord, by the petitioner and his friend from the house of the informant, who was working by then as a constable of the concerned police station. And they both are young, my lord, the girl and the petitioner at that time. The girl is around, my lord, from the finding of the court, it is below 17 years, and the boy is around 19 years. At the night of 28th November 1992, the victim asked her mother to go outside for to pass urine, my lord. And after that, she asked her mother to bring water. And immediate after that, when the mother of the victim came outside and found that her daughter is nowhere there, she raised hula, and the informant, the father, lodged the FIR before the police. And later it was, after investigation, it was found that these two boy taken the girl to West Bengal, and she subsequently found after 18 days on 1992. My lord, it is the case of the prosecution that the girl is minor. That's why, my lord, the girl, our sentence awarded under section 363(6) and 363. And my lord, it is the defense plea is that the girl on her own went away with that boy because they're in love, and there is some documents and exhibits or file exhibit A, which shows that they're in love. My lord, I pray, my lord, if it may not cover under PO Act, but my lord, I request, my lord, that the period they have undergone, the accused who were young at that time, can be considered, my lord.
What is the period?
My lord, I only have the, my lord, after revision was filed, they were released on bail after 26 days. And after trial court judgment, my lord, I don't have the record with me. And my lord, even noting says that LCR is not there.
What is the date of occurrence?
Date of occurrence is, my lord, 28th November 1992.
And what is the evidence of the victim?
Well, the victim was not examined because she is dead at the time of examination.
She was
Not
dead?
in a normal circumstances, my lord. Here it was not explained. Not from this.
So any evidence was laid on the point of absence of the victim?
My lord?
Whether at the trial any evidence was laid as regards the victim's death?
No, my lord.
How do you say that?
Because she was recovered on 16/12/1992. It was written in the judgment. And after that, there is a finding of the learned triad court because she was not examined, because by that time she is dead. Your Lordship may kindly see para number 6 towards my lord middle. There is the LOPWC clearly stated,
Paragraph 6 of?
learned trial court judgment. The LOPW6 clearly stated that on 16/12/1992.
Trial court judgment is where is the trial court judgment? Just and what about 376?
Well, 376 was not made out. Well, it was trial court held that it is not made out.
Age was proved.
My lord, it was the finding of the trial court that
Yes.
the age is not more than 17 years. The doctor was also examined, who was examined the victim. Exhibit A was filed, which is an affidavit shown by the victim girl that she is above 18 years of age on the same day of occurrence, means 28 on the same day of occurrence. So in the during day, she's shown an affidavit at Udara court that she is 18 years of age, 18 years old, and thereafter in the night the incident happened, my lord. Exhibit A is filed. So, my lord, all these things has not been examined because the victim girl at the time of trial is dead.
All right. Next.
Lordships. Close this. Lordship, close this matter.
No, I'll dictate the order.
No, in that case, not so. My name may not be there.
Your name will be there. It will come under the same heading.
No. Mr. Arnav Behra will be there because
All right.
I was there in my senior's office when the matter was filed, not so.